And he is the witness that's going to be testifying by Zoom. He's not currently in the state. I will ask my investigator to instruct him about, not.
Fair enough. Investigator Jackson, will you take care of that this morning?
Yes, Your Honor.
All right, thank you. All right, fair enough. Anything else that we need to consider outside of the presence of the jury at this time? Regarding the initial instructions, Ms. Kelly, there is an instruction regarding the defendant's right to remain silent, and that is to be given at your discretion and request. Do you have any specific position on that issue?
We can go ahead and give it. We haven't had a final conversation about whether or not
Sure.
Mr. Lawson is going to take a stand, but we can go ahead and give it.
All right. And then I'll certainly read the note taking by jurors. Ladies and gentlemen, if you've been subpoenaed to be a witness at the trial today, please stand. All right, ladies and gentlemen, please understand that you are now under what we call the rule of sequestration. What that means is that you may not speak to each other or anyone else other than the attorneys in this trial regarding the testimony that you would give during this trial while this trial is proceeding. Do any of you have any questions regarding the rule of sequestration? All right, seeing no questions, then you guys are free to go wait in the witness waiting area, wherever they've asked you to wait. Okay, thank you guys very much. I've got to pull up my 2.1. I'm having a little bit of trouble with it.
Any questions? Okay.
Are there any other matters that we need to consider outside of the presence of the jury?
Just for clarification, are we questioning seated or standing as usual?
I see no reason why the attorneys can't stand
Okay.
and ask the questions. Why don't we, Chuck, oh, in a minute, I'll ask him to move the podium. We'll move the podium by the jurors like we normally do. And what we will do, though, is if there is a need for a sidebar, we will get the jurors to leave the courtroom.
Okay.
So that it does not seem weird that the defendant's not getting up. Okay, unless you would prefer a different procedure, Ms. Kelly?
That's fine, Your Honor.
Okay. Any anticipated evidentiary objections to any of the testimony? I mean, I will not hold you to this, of course, but can you anticipate any evidentiary objections that you have right now to any of the substance of any of the witness testimony that we could go ahead and address a potential argument?
Nothing comes to mind, or I would have filed a motion in limine.
Okay, and so we'll see how the trial progresses.
Remember, the plan for Officer McCrary is that when the witness before him, Eddie Myrick, is called to the stand, my staff is going to contact Mr. McCrary on Zoom. So he'll be on Zoom for however long. Officer Myrick.
So McCrary goes after Myrick. So we probably need to take a quick Zoom break, or excuse me, a quick break in anticipation of the Zoom, correct?
We can, or I mean, it's to the court's pleasure. I think
He's going to be pretty good to get on and all that.
I think so.
Okay.
Unless
Well, let's just play it by ear. Let me then go ahead and connect by Zoom. Are they here? He's bringing, okay, so our jurors are here. They're bringing them up to the jury room. And like I indicated, they're coming in the side door, coming in and out of the side door. Give me 1 second. Let me connect to Zoom myself so that I can see when he gets online. And I will be certain to move that individual to a waiting room as soon as I see him come on, so that he does not hear any of the testimony that is going on during the trial. Do we have any witnesses that have just walked in, Ms. Jeffcoat?
No, Your Honor.
All right, fair enough. You guys can have a seat wherever. We're about to bring the jurors in. Any pretrial instructions that you anticipate or during the trial instructions, like recordings or anything like that we're going to need during the trial?
There's a surveillance video, but there's no like recorded statements or anything like that.
Okay. What about redactions? Do we need to read the instruction about redactions?
No, Your Honor, the surveillance video is not in.
Does this defense agree regarding the surveillance video and any need for additional instructions?
We agree, Your Honor, that there's no audio to it, and I think the clips are fairly short, so there's any reductions, and can't think of any issues sort of.
Yes, Ms. Green?
I plan to let Inspector Bassford kind of manage playing the video because he's better with
Sure. Okay, so you're going to let him do that? Okay.
Get it loaded up and then give him announcements.
Sure. Okay, fair enough. Let me know when they're here. Is our white noise on? Okay, white noise is on. Excellent, thank you. They're going to tell us when they're ready, right, Chuck? Okay. We ready?
Yes, ma'am.
Everybody ready for the jurors to come in the courtroom? Let's remain seated for our jurors to enter the courtroom.
You're in the courtroom.
Good morning, ladies and gentlemen. Welcome. State, is this your jury?
Yes, it is, Your Honor.
Defense, is this your jury? Madam Clerk, please place our jurors under oath.
Raise your right hand. Do you solemnly swear or affirm that you will well and truly try the issues between the state of Florida and the defendant and render a true verdict according to the law and the evidence, so help you God?
Good morning, ladies and gentlemen. Members of the jury, excuse me, Members of the jury, you have been selected and sworn as the jury to try the case of the state of Florida versus Joshua Lawson. This is a criminal case. Joshua Lawson is charged with aggravated manslaughter of an officer. The definition of aggravated manslaughter of an officer will be explained to you later. The state's charging document, which is called an information, is not evidence and is not to be considered by you as any proof of guilt. It is my responsibility to explain the law to you. It is your solemn responsibility to determine if the state proved its accusation beyond a reasonable doubt against Joshua Lawson in accordance with the law that I provide to you. Thus, the province of the jury and the province of the court are well defined and they do not overlap. This is one of the fundamental principles of our justice system. Before proceeding further, it will be helpful if you understand how a trial is conducted. At the beginning of the trial, the attorneys will have an opportunity, if they wish, to make an opening statement. The opening statement gives the attorneys a chance to tell you what evidence they believe will be presented during the trial. What the lawyers say is not evidence, and you are not to consider it as such. Following the opening statements, witnesses will be called to testify under oath. They will be examined and cross-examined by the attorneys. Documents and other exhibits may be introduced as evidence. After the evidence has been presented, the attorneys will have the opportunity to make their closing arguments. Following the closing arguments by the attorneys, I will instruct you on the law that is applicable to this case. After the final instructions are given, you will then be released to retire and to consider your verdict. You should not form any definite or fixed opinion on the merits of this case until you have heard all of the evidence, the argument of the attorneys, and my instructions on the law. Until that time, you should not discuss the case amongst yourselves. Your verdict must be based solely on the evidence or the lack of evidence and the law. I now instruct you not to communicate with anyone, including your fellow jurors, about this case. No communication includes no posting information on the internet, emailing, or any other form of communication. You cannot do any research about the case or look up any information about the case. If you become aware of any violation of these rules at all, please notify one of our bailiffs of that violation. During the trial, the court will take recesses, and you will be permitted to go about your personal affairs. During those recesses, you must not discuss the case with anyone, nor permit anyone to say anything to you or in your presence about the case. If anyone attempts to say anything to you or in your presence about the case, tell him or her that you are on the jury trying the case and ask that person to stop. And that's why we've given you juror buttons to identify you as jurors. If he or she persists, leave that person at once and immediately report the matter to one of our bailiffs. They will then advise me. All cell phones, computers, tablets, or other types of electronic devices must be turned off while you are here in the courtroom. Turned off means that the phone or other electronic device is actually off and not in a silent or vibrating mode. You may use these devices during recesses, but even then, you may not use your cell phone or electronic device to find out any information about the case or communicate with anyone about the case or the people and places involved in the case. Do not take photographs, video recordings, or audio recordings of the proceedings or of your fellow jurors. After each recess, please double check to make sure that your cell phone or electronic device is turned off. At the end of the case, while you are deliberating, you must not communicate with anyone outside of the jury deliberation room. You cannot have in the jury room any cell phones, computers, or electronic devices. Therefore, if someone needs to contact you in the event of an emergency, the court can receive messages and deliver them to you without delay. A contact phone number has been provided. The phone number that's on your jury deliberation table is that of Clay Rooks, and that's our elected clerk of court. Please give any friends or family members that number. If you are in the middle of deliberations and they need to get an urgent message to you, they're to contact that number, and that's how they can reach you. The case must be tried by you only on the evidence presented during the trial in your presence, in the presence of the defendant, the attorneys, and me. Jurors must not conduct any investigation of their own. This includes reading newspapers, watching television, or using a computer, a cell phone, the internet, any electronic device, or any other means at all to get information related to this case or the people and places involved in this case. This applies whether you are here at the courthouse, at home, or anywhere else. You must not visit the places mentioned in the trial or use the internet to look at any maps or pictures to see any place discussed during the trial. Jurors must not have discussions of any sort with friends or family members about the case or the people and places involved. Do not let even the closest family members make comments to you or ask questions about the trial. In this age of electronic communication, I want to stress again that just as you must not talk about the case face to face, you must not talk about the case by using an electronic device. You must not use phones, computers, or other electronic devices to communicate. Do not send or accept any messages or ask for advice related to this case or your jury service. What are the reasons for these rules? These rules are imposed because jurors must decide the case without distraction and only on the evidence presented in this courtroom. If you investigate, research, or make inquiries on your own, I have no way to make sure that the information you obtain is proper for the case. The parties, likewise, have no opportunity to dispute or challenge the accuracy of what you find. That is contrary to our judicial system, which assures every party the right to ask questions about and challenge the evidence being considered in this courtroom and to present argument with respect to that evidence. Any independent investigation by a juror unfairly and improperly prevents the parties from having that opportunity that our judicial system promises. Any juror who violates these restrictions jeopardizes the fairness of these proceedings, and a mistrial could result and would require the entire trial process to start over. A mistrial is a tremendous expense and an inconvenience to the parties, the court, and the taxpayers. If you violate these rules, you may be held in contempt of court and face sanctions such as serving time in jail, paying a fine, or both. In every criminal proceeding, a defendant has the absolute right to remain silent. At no time is it the duty of the defendant to prove his innocence. From the exercise of a defendant's right to remain silent, a jury is not permitted to draw any inference of guilt. And the fact that a defendant did not take the witness stand must not influence your verdict in any manner whatsoever. The attorneys are trained in the rules of evidence and trial procedure, and it is their duty to make all objections that they feel are proper. When an objection is made, you should not speculate on the reason why it is made. Likewise, when an objection is sustained or upheld by me, you must not speculate on what might have occurred had the objection not been sustained, nor what a witness might have said had the witness been permitted to answer. During the trial, it may be necessary to confer with the attorneys outside of your presence to discuss matters that require consideration by me alone. It is impossible to predict when such a conference may be required or how long it will last. When such conferences do occur, they will be conducted so as to consume as little of your time as is absolutely necessary for a fair and orderly trial of this case. Is there any objection to the reading of Standard Rule 2.1?
No, Your Honor, no objection to the state.
If you would like to take notes during the trial, you may do so. On the other hand, of course, you are not required to take notes if you do not want to. That will be left up to each of you individually. You have been provided a notepad and a pen for your use if you wish to take notes. Any notes that you take will be for your personal use. However, you should not take them with you from this courtroom. During recesses, our bailiffs will take possessions of your notes and will return them to you when we reconvene. After you have completed your deliberations, the bailiff will deliver your notes to me. Those notes will be destroyed because I will personally destroy your notes. And I want you all to know that no one will ever read your notes, including me. If you take notes, do not get so involved in note-taking that you become distracted from the proceedings. Your notes should only be used as aids to your memory. Whether or not you take notes, you should rely on your memory of the evidence, and you should not be unduly influenced by the notes of other jurors. Notes are not entitled any greater weight than each juror's memory of the evidence. Is there any objection to the reading of standard instruction 2.1A?
No, Your Honor.
All right, is the state ready to proceed with its opening statement?
Yes,
Ms. Jeffcoat, you may proceed.
Gentlemen of the jury, Shayla Jeffcoat, and today I'll be representing the state of Florida and state Joshua Lawson. Every one of us faces some level of risk when we just roll out of bed in the morning, just going about your daily business, driving to work, things like that. They all carry some level of risk, but some jobs, like the job of Matthew Sanders, carries a higher level of risk. As a corrections guard, Mr. Sanders worked around people that had already been found to be in violation of the law and were serving sentences for a range of different crimes. And on March the 18th of 2021, Captain Matthew Sanders went to his job at the Graceville Correctional Institute. The events leading up to Captain Sanders' death actually began outside of his presence. You'll learn that on March the 18th, an officer named Gregory Dosick got a call to a disruptive inmate. That inmate was Joshua Lawson. Gregory Dosick responded to the dormitory area where Mr. Lawson was housed. He was being disruptive. Gregory Dosick instructed the inmate to cuff up. That was their standard procedures to put cuffs on. And the inmate refused. He not only refused, but he requested to speak to the captain. So Officer Dosick and inmate Lawson start walking towards the captain's office. And you'll see surveillance videos. There's cameras in various locations on the institute grounds. And you will see video footage of the two men walking towards the captain's office. They have to go through a couple of different gates. And you'll be able to see in the video that the defendant is not cuffed. And while there's no audio, you can tell by gestures and if you watch the video closely that the inmate is steadily talking. Okay? He appears to be agitated. They get to the captain's office, and the captain's office is basically it's in a building that opens to kind of a ground or a quad area, a grassy area. There's a sidewalk that runs down in front of the captain's office and other offices in that building. And there's a camera at one end that shows that whole kind of length of sidewalk in the captain's office. And so you will see the officer go inside to get the captain. You'll see the captain come out, and you will hear testimony from witnesses, other officers who observed what was going on. You'll also see camera. We'll learn that Captain Sanders, again, told the inmate, the defendant, to cuff up, which is, again, standard practice. The inmate, again, refused to comply with that request. You will see Captain Sanders reach through the inmate's arm as if to place cuffs on him. And at that point, the inmate starts to swing at the captain. He grabs the captain kind of around the torso area. They actually have each other around kind of the torso area, almost in a bear hug. And the inmate, the defendant, is able to pick Officer Sanders up, Captain Sanders up, and fling him or throw him to the ground. And you will see that Captain Sanders does not get back up from that ground. After the defendant throws the captain to the ground, he runs, and there are other officers that take custody of him. But you will see Captain Sanders laying there on the ground. Anticipate you will later learn that the reason that the captain does not get up is that he has broken his hip. That the fall, the slamming onto the concrete sidewalk here by the inmate has broken Captain Sanders' hip. He is taken to the hospital. He has surgery. You will hear testimony from both his wife and from the medical examiner, Dr. Radke, that this injury required surgery. And Captain Sanders is eventually released to the hospital, and he goes home. Remember, these events all take place on March 18th, the incident with the inmate where the captain slammed to the ground. So he's recuperating at home with his wife, and things seem to be going, well, he seems to be improving. He's in pain. His wife talked about, that she could tell he was in pain, but that it's starting to get a little better. And then on April the 7th, he gets up in the night. He had been sleeping in kind of a medical chair type device to try to that would help him get out of bed or get up on his own. And she had been sleeping on the couch next to him so that they could be together. But he apparently has gotten up on his own. She wakes up in the night to him hollering for help. She makes it to, she gets up, she sees that he's not in his chair, and she finds him in the hallway where he has collapsed possibly on the way to go to the restroom. And he dies right there in front of her. A autopsy is performed on Captain Sanders, and the captain was killed due to the breakage of the hip. The break in the hip caused what's called a pulmonary embolism. It's basically a major blood clot that ultimately causes his demise. Dr. Radke will testify that the pulmonary embolism is a known result of such hip fractures. It occurs in about, maybe not to the extent that Captain Sanders did, but they do occur, these kind of giant clots occur in about 30% of hip fractures. So members of the jury, I will ask you to listen closely to all testimony and all evidence in this case and to find the defendant guilty of this charge. Ms. Kelly,
Thank you, Your Honor.
is the defense ready to proceed?
Yes, we are, Your
You
Honor.
may proceed.
Thank you. Good morning, ladies and gentlemen. Normally, when someone's charged with a crime or we have a trial, we kind of know a crime was committed, and the question is who was it committed by? So a lot of times in trials, we try to show that the wrong person was arrested for a crime that we knew occurred. This is a little bit different situation. You're going to see a video and you're going to see what happened. But the question that you're going to be left with is what crime, if any, was committed? You'll see that as Officer Dosick and Mr. Lawson are walking through the corridors, Mr. Lawson is in no way aggressive. He's not bowing up. He's just walking to the captain's office, and he had requested to see the captain. You'll listen that he had never met Captain Sanders before. They had no history. They had no prior run-ins. There was no animosity. There was no ill will when this occurred. You'll hear that they were engaged in a scuffle. You will hear that Captain Sanders was about a foot taller and about 100 pounds heavier than Mr. Lawson. So you'll see that what occurred was quick. It was a matter of a second, maybe two, and Mr. Lawson immediately walked away. He didn't proceed. He didn't keep trying to fight or anything like that. You'll hear that Captain Sanders was injured, that he had surgery, that he went home, he was released from surgery. You'll hear that he had several prior medical conditions which predisposed someone to blood clots. You'll hear that he tried to tell the doctor that something was wrong, and the doctor didn't do anything about it. He said, it's fine, it's normal. So you'll hear about all of these other factors, and at the end of the trial, after you've looked at all of the evidence, after you've listened to all of the witnesses, after you've watched the video, at that point, I want you to ask yourself, what, if any, crime was committed? And you can come back and say some crime was committed, but it doesn't, even if you don't think it's the crime that was charged. So I appreciate your attention, and thank you.
Ms. Jeffcoat, is the state ready to call the first
Witness,
Your Honor, the state would call Winona Sanders.
Winona Sanders, please. Ms. Sanders, good morning. Before you take the witness stand, please raise your right hand for Madam Clerk to place you under oath. Ms. Sanders, both the chair and the microphone on the witness stand adjust. Please adjust them both so that you're able to speak loudly and clearly into the microphone. Ms. Jeffcoat, your witness.
Thank you, Your Honor. Good morning, ma'am. Could you please state your name to the jury? Your Honor, is it okay?
Oh, absolutely.
Winona Sanders.
And ma'am, what do you do for a living?
I'm retired correctional officer, lieutenant.
And ma'am, were you married?
Yes,
And what was your husband's name?
Matthew Craig Sanders.
And what did Matthew Sanders do for a living?
He was a correctional officer captain at Geo Corporation in Graceville.
And how long were you and Captain Sanders married?
It would have been 19 years, April 2021.
In April of 2021, is that when he passed?
Yes, ma'am.
I want to take you back to March the 18th of 2021, the day of his injury. Did you see him that day before he went to work?
Oh, yes.
Okay. And was he in good health at that time? Did he appear fine, walking fine, everything like that?
Yes, ma'am.
And anything unusual going on before he left for work that day?
No, ma'am.
When and what do you remember what you did that day when he left for work?
Just my usual clean house and do laundry kind of thing.
Do you recall being notified that the captain had been injured?
Yes,
And how were you notified?
via telephone.
Who called you?
My sister.
And do you know how she had found out?
Her husband worked there.
So you learned that Captain Sanders is injured, and what do you do as a result of that?
Well, they said they were taking him to the hospital, and I got my clothes on and I headed that way.
Okay. And which hospital did you go to?
Flowers in Dothan.
Did he get there before you or the other way around?
I got there before he did.
So you hightailed it
Yes, ma'am.
to Flowers Hospital. And when he arrived, when did you first see him?
When they opened the ambulance doors, and he was in a lot of pain.
And how could you tell that he was in pain?
He was hurting. He was telling me it hurt so bad.
Okay. And you had been with him for many years at that point, so you could tell,
Yes,
being his
ma'am.
wife probably, that he wasn't right. Did he stay there at the hospital?
Yes. They admitted him
They admitted him. Okay. And did he end up having surgery?
the very next day. Yes.
Do you remember about how long he stayed at the hospital before you take him home?
He was discharged on the 22nd
All right, of March.
of, yes, March.
Okay, so he has surgery the following day and then gets discharged a few days after.
Yes, ma'am.
When he got discharged, did you guys return to your house?
Yes, we did.
And what was kind of the setup there when you guys got back to the house for him? I'm assuming he was not walking normally at that point.
No, we had to get one of those lift chairs, and he basically just slept in that
And where was the lift chair located?
in the living room.
And did you stay in the bedroom and him in the living room?
Oh, no, ma'am. I slept on the couch right there.
Okay, just to be near him. in
Yes,
case he needed
ma'am.
anything. And from March, you said he got released from the hospital March 22nd. How did he do the days after that? Did he make any progress?
He did. He was up. He finally was able to walk to the bathroom with a walker, That took a few days to get to that point. And
And that was, I guess, a pretty big milestone.
it
for people
was.
to go to
It
the bedroom.
was.
I can imagine. And tell us again what else he was able to do?
Well, he was able to, well, that's basically mostly what he did was walk to the bathroom
Okay.
and back.
And I want to take you now to April the 7th. Okay. When you went to sleep that night, was it still on the couch?
Yes.
And how had he been doing up to that point? Was he making steady progress?
As far as getting around, he was doing a lot better. We had plans to go to Mariana because we had been to the doctor on the 6th, and then we were going to go to Mariana the next day just to get him out of the house.
Okay. Was that something y'all were looking forward to?
Oh, yes, he was.
I bet. Being cooped up in the house is no fun, I'm sure. So you guys went to the doctor on the 6th. You're making plans to go to Mariana on the 7th. And tell me when you realize that there's a problem, that there's something is wrong.
Well, at about, I don't know, it's been 9 or 9:30 that night. I had got his water and everything and had him set up for the night. And I told him that I was just going to lay down on the couch, and if he needed anything, just to let me know. And I fell asleep soon after that. And then about midnight, I heard somebody yelling, "Help me, help me." And I jumped up and I ran down the hall, and there he was laying in the hall. And I said, "What happened?" He goes, "I can't breathe." And so I was just going to set him up, and then going to try to help him get up. When I set him up, he passed out, I thought.
Okay.
And so I ran and got the phone and called 911. And everything just went out of my head. I just told the lady, I said, "You got to help me, tell me what to do." And she was helping me go through the CPR thing. And I tried and tried, and the ambulance got there, and then they put I guess a machine on him, EKG machine. I don't know what it was, but she looked at me and she said, "Ma'am, he's gone." And then my whole world just turned upside down.
From the time that he passed out, when you lifted him up, did he ever regain consciousness?
No, ma'am.
And so EMS comes and they tell you that he is gone. And what happens after that?
Then the deputy came and he took my statement and everything. And then the funeral home came and they picked him up
Did you stay with him until the end?
the whole time.
Thank you, ma'am. I'm going to consider this.
Ms. Kelly, do you wish to cross-examine this witness?
Yes, thank you, Your Honor.
Your witness, Ms. Kelly.
Thank you. Ms. Sanders, prior to this incident occurring, had Captain Sanders had any sort of health issues?
He was a diabetic and he had a kidney removed, and he had some thyroid issues, and he had cancer. And I believe it was 2009.
What sort of exercise regimen did he have?
He was just very active at his job, and then when he come home, he'd mow grass and do lawn work and things like that. He wasn't a jogger or anything like that.
Okay. Did he go to the gym or anything like that?
We did for a little while, but then we quit like everybody else does.
Problem. Okay. And when I believe you testified that he was originally discharged on March 22nd.
Yes, ma'am.
Okay, when he was discharged, did the hospital give him clean bill of health at that point? I mean, other than obviously still recovering from the injuries, but did he appear to be?
Yeah, all he was in pain.
And once you got home, did they give you any sort of therapeutic or preventative measures for him to do at home?
Well, they had a physical therapy person come in for him to get him back going.
Do you know if they had him on any sort of blood thinner, heparin, anything?
They had him on, not heparin, they had him on a 325 aspirin.
Okay, so they just had him on aspirin.
Yes, ma'am.
But no, to your knowledge, no prescription blood thinners?
No, ma'am.
Did he have any sort of history of heart disease, family history of heart disease?
His mother had a heart attack, but he didn't have it.
Did he have high blood pressure?
He was on high blood pressure medicine, but it was because of his diabetes. But he really didn't have real high blood pressure or anything.
Did they give him any sort of compression socks or the little inflatable tubes they put on your legs?
No, ma'am.
Okay, so there was no clot prevention from the doctors at that point?
Just the aspirin.
Okay. And you indicated that you went to the doctor the morning of the 6th.
Yes, ma'am.
And then he passed between the 6th and the 7th. When he went to the doctor's office on the 6th, was there anything that he was telling them that was going on then that was kind of out of the
He
ordinary?
had spit up some little blood clots, and we notified the doctor of that.
Okay, so prior to him going to the doctor, he was already coughing up some blood clots?
Yes, ma'am.
Okay, about how long has that been going on?
I think he just did it maybe once or twice.
Okay. And then did the doctor do anything once you informed him of that he was spitting up clots?
No, ma'am.
Thank you. I have any more questions?
Any redirect by the state?
None of this time.
Councils, may this witness be released, or do you wish for her to remain subject to recall?
I don't either, Your Honor.
All right. Ms. Sanders, you are released from your trial subpoena. What that means is that if you wish, you may now remain in the courtroom. Okay, thank you. Yes, you may have a seat. Ms. Jeffcoat, do you wish to call your next witness?
Yes, Your Honor. The state would call Gregory Dosick.
Gregory Dosick, please. Mr. Dosick, good morning. If I could please have you raise your right hand to be placed under oath by Madam Clerk.
Do you solemnly swear or affirm that the evidence you're about to give in this case shall be the truth, the whole truth, and nothing but the truth?
Mr. Dosick, both the chair and the microphone on the witness stand adjust. Please adjust them both so that you're able to speak loudly and clearly into the microphone. Ms. Jeffcoat, your witness. If you'll adjust your mic as well so that we don't have audio issues with our jury, that'd be great. Can everyone hear everyone well? Okay, excellent. Go ahead, Ms. Jeffcoat. Sir, can you please state your name for the record?
It's Gregory Dosick.
And sir, where do you work?
I work at Blackwater Correctional Facility.
And what do you do at Blackwater Correctional?
I'm a lieutenant.
All right. And before working at Blackwater Correctional, did you work for GEO at the Graceville Correctional Institute?
Yes, ma'am.
All right. And were you working there on March the 18th of 2021?
Yes, ma'am.
Approximately how long had you been working at that facility at that time?
Roughly 3 years.
All right. And did you, are you familiar with an inmate named Joshua Lawson?
Yes, ma'am.
Do you see Mr. Lawson in the courtroom today?
Yes, ma'am.
Can you point to him and tell us what he's wearing?
That black jacket and button-up shirt.
And if Your Honor, if the record will reflect, he's identified the defendant. The record will so reflect. Going to March the 18th of 2021, did you have any interaction with the defendant?
Yes, ma'am.
And where did you first interact with the defendant? Where did you first see him?
Inside of Alpha Dorm.
Inside the Alpha Dorm. Was that where he was normally housed?
Yes, ma'am.
Okay. And what was your reason for going to Alpha Dorm?
He was refusing to submit to hand restraints.
Okay. And were you summoned there, or were you present when he initially refused to submit?
I was called over the radio.
Okay. So when you get there, tell us what you do.
I speak to Mr. Lawson. He refused to still submit to hand restraints. At this time, I took him to my supervisor.
Okay.
And that's-
And what was Mr. Lawson's demeanor like when you first started interacting with him?
He just didn't want to follow orders.
Okay. And is submitting to hand restraints, is that a normal procedure at the prison?
Yes, ma'am.
Okay. And is that, I mean, that's something that's routinely done. Inmates are asked to put on hand restraints.
Yes, ma'am.
Okay. And so when he refused to submit to hand restraints, was he saying anything?
He just said he wasn't going to put them on.
Okay. Did he make any requests to speak with anybody else?
No, ma'am.
Okay. And then why did you end up taking him to see the captain?
That's the next chain of command.
Okay.
Take him to the captain.
Okay. So as you go to the captain, does he agree to walk with you to the captain's office?
Yes, ma'am.
Okay. And was he being calm, or was he saying anything? Tell us about how he's acting.
He didn't say anything. He just walked beside me.
Okay.
Okay. And when he walked with you to the captain's office, he wasn't struggling or anything, right? He agreed to walk with you.
Yes, ma'am.
Okay. Tell us what happens when you get to the captain's office.
I let the captain know what was going on, and he stepped out of the office to talk to him. Mr. Lawson had an ink pen in his hand previously before captain stepped outside.
An ink pen?
Yes, ma'am. We did
Okay.
take the ink pen from him.
Okay.
He handed it over.
Okay.
The captain instructed Mr. Lawson to submit hand restraints,
Mhm.
which he refused. The captain attempted to place hand restraints on him.
Okay. And again, what do you guys normally do when somebody won't submit to hand restraints?
Force can be utilized
Mhm.
if he refuses to submit to hand restraints.
Okay.
We normally give them several orders to submit first,
Sure.
and that's the process for that.
Okay. And so at this point, I guess another officer before you couldn't get him to submit, and then you were called and
Yes,
you couldn't get him to submit. So now you've gone to the captain. And so this is kind of just the next step in the chain.
Yes, ma'am.
Okay. So what happens when the defendant refuses to submit to hand restraints at the captain's request?
The captain attempts to place hand restraints on Mr. Lawson, and at this time, you can observe Mr. Lawson flip the captain over his shoulders.
Okay. And does the captain go to the ground? Does he fall to the ground when he's flipped over his shoulders?
Yes, ma'am.
Okay. And when he goes to the ground, what do you do? What happens at that point?
I utilize chemical agents on Mr. Lawson in
Okay.
attempts to get him into hand restraints.
Okay, so this is like an escalation of force,
Yes,
right?
ma'am.
Okay. And are you and another officer eventually able to get the defendant into hand restraints?
Yes, ma'am.
Okay. Now, at some point, do you go back and see the captain? Or did you leave with the inmate?
Me and the other officer took the inmate to confinement.
Okay, all right. And did you speak or see the captain anymore that day?
I seen him before he left
Okay, and how did he leave?
on an ambulance.
On an ambulance, okay, all right. Your Honor, at this time, I'll tender this witness.
Does the defense wish to cross-examine this witness?
Yes, Your Honor.
Ms. Kelly, your witness.
Okay, thank you, Your Honor. Officer Dosick, I believe you said at some point pepper spray was employed.
Yes, ma'am.
Okay, was that before or after the scuffle with Captain
It
Sanders?
was after.
After? Okay, and as you were escorting him to see Captain Sanders, you indicated that he was not saying anything.
No, ma'am, he was not.
Okay, and y'all had requested that he turn over a pen,
Yes,
and,
ma'am.
and he did so willingly?
Yes, ma'am.
Okay. Were you investigated for making false statements?
No, ma'am.
You weren't?
No, ma'am.
Okay, for not turning over money or something like that?
No, ma'am.
Okay.
We may. Come on up, guys. Hold on, Ms. Kelly. Madam. Ms. Kelly, your witness, and you may proceed.
Thank you, Your Honor. Your Honor, at this point, I'm going to tender the witness subject to recall.
All right. Anything further from the state at this time? Mr. Dosick, you are still under your trial subpoena. What that means is that the rule of sequestration that I explained earlier to you still applies, and you are subject to recall. So if you will continue to wait in the witness room, that would be great. All right, thank you. Does the state wish to call its next witness?
Yes, Your Honor, the state will call Officer Eddie Myrick.
All right, Officer Eddie Myrick. Officer Myrick, good morning.
Morning.
Please raise your right hand so that Madam Clerk can place you under oath. If I could please have counsel's approach, no court reporter necessary. Jeannie, go ahead and put it back on. White noise back on, just for a minute. All right. Mr. Myrick, I may have already said this, but both the chair and the microphone adjust. Please speak loudly and clearly
Yes.
into the microphone, okay?
Okay.
Ms. Jeffcoat, your witness.
Sir, can you please state your name for the record?
Officer Eddie Myrick.
And what do you do for a living, sir? What do you do for a living?
Where do I live?
No, what kind of job do you
I'm a
have?
correction officer.
Okay, sorry, let me get this microphone just a little closer. And how long have you been working in corrections?
Right now, about 17 years,
All right. And which facility do you work for?
Graceville.
All right. Were you working at Graceville on March 18th of 2021?
Yes,
And did you work with a Captain Sanders?
yes.
And how long had you worked with Captain Sanders?
At that time, it was about 14 years.
About 14 years. Okay. And do you recall an incident on March the 18th where Captain Sanders was injured?
Yes.
What position were you working? Like what was your area where you were working at the time of
The-
that?
The North Gate.
All right. And what were you doing at the North Gate?
North Gate, where we direct inmates to the call outs,
All right.
education.
Okay. And did you see, what did you see happen to Captain Sanders?
I saw inmate Lawson pick him up, body slam him.
Okay. And do you see inmate Lawson in the courtroom today?
Yes,
And can you point to him and tell us what he's wearing?
here.
Okay. And Your Honor, if the record reflect he's identified or he's pointed to the defendant, can you tell us what color shirt he has on?
It's plaid, look like blue or black.
Okay. Your Honor, if the record reflect he's identified the defendant.
The record will so reflect.
Sir, when you saw that happen, what did you do?
I went to assist to, I tried to get there, didn't get there in time, but
Okay.
he started running to the south end of the gate, and that's when I saw Officer McCrary and Officer Dosett. And I went to help restrain him, but they had already had him restrained.
Okay, so he ran towards
South gate,
the south gate, which was away from, I'm assuming, the north gate.
right,
Okay, and so by the time you got to them, he had already been taken into custody. Is that
Yes.
correct? Okay, what did you do after that?
I went back and assist Captain Sanders stay by his side.
Okay, and was he able to get up on his own?
No,
Okay, do you recall if an ambulance was called?
I do not recall.
Okay, did you, are there surveillance cameras at the facility at Graceville Correctional Institute?
But I know it's on the walk,
Okay.
both ends of the walk.
All right. And have you had an opportunity to watch some of the surveillance where this incident occurred?
Yes,
Okay. And does that accurately show what you recall happening? In
Yes.
scene? Okay. Your Honor, may I briefly-
You may.
Sir, I'm going to show you what's been marked as State's Exhibit A, just for identification purposes. And looking at this disc, can you tell me if you have any identifying marks on there that you recognize it?
yes, my initials,
Your initials. And so after watching the video on this disc, did you initial it?
yes.
Your Honor, I'm going to tender the witness.
Does the defense wish to cross-examine this witness?
Yes, thank you, Your Honor. Officer Myrick, when all this occurred, where were you standing?
Excuse me,
Where were you standing?
at the north gate, at the podium.
Okay, so correct me if I'm wrong, but you were at the north gate and they were between you and the south gate?
Mhm.
Okay, so you kind of were behind everything that was going on?
Yes, black, it's your seat.
Okay, so you were facing that direction?
Yes,
All right. Have you watched the video?
yes,
So from my view of the video, it kind of looks like inmate Lawson is just past, or Mr. Lawson's just past the guards, but you could see Mr. Lawson and all that the entire time.
yes.
All right, thank you. I don't have any more questions.
Anything further from the state, from this witness?
Your Honor, we would ask that you remain subject to recall.
All right, Mr. Myrick, you are still under your trial subpoena, and the rule of sequestration that I instructed you about earlier this morning still applies. So if you will, please go back to the waiting room and remain subject to recall. Thank you. Ms. Jeffcoat, our witness on Zoom is present. Does the state wish to call its next witness at this time?
Yes, Your Honor, the state would call Officer Cody McCrary.
Madam Clerk, if you will, please put Polycom TVs. Ms. Jeffcoat, he was on Zoom. I put him in a waiting room. Could you have someone call as well and see if he may not have understood that, because I couldn't let him hear the other testimony.
I believe
That's him. I see him, but I don't see him in my room, in my Zoom room. Guys, bear with us. The technology is always, I see him. He just logged back on. Officer McCrary, this is Judge Garcia. Are you able to hear me and see me? I'm going to chat with Mr. McCrary, Officer McCrary, and ask him to please turn on his computer audio.
Hello?
Officer McCrary, can you hear me? This is Judge Garcia.
Yes, ma'am.
All right. Officer McCrary, just give me 1 second. Tell me, what state are you currently in, officer?
I'm currently in Minnesota.
Ms. Jeffcoat, as an officer of the court, can you represent to me that he is who he purports to be?
Yes, Your Honor, I personally met with Officer McCrary the last time he was in town. We had flown him down here for a different trial. And I met with him at that time.
And does the defense have any objection to that introduction?
No, Your Honor.
Officer McCrary, do you have any objection to me placing you under oath while you are in a different state and I am in the state of Florida?
No, ma'am.
Officer McCrary, if you will, please raise your right hand. Sir, do you solemnly swear or affirm that the testimony that you are about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am, I do.
All right. Thank you, Officer McCrary. Ms. Jeffcoat, your witness.
Thank you. Good morning, sir. Can you please state your full name for the record?
Kobe Kente McCreary.
All right. And Officer McCrary, what do you do for a living?
I'm a federal correction officer at the moment.
All right. And you're a federal correction officer, and do you work up there in Minnesota where you're at now?
Yes, ma'am.
Okay. And before going into federal corrections, did you work in corrections in the state of Florida?
Yes, ma'am.
And can you tell us where you were working back on March the 18th of 2021?
At Gracefield Correctional Institution.
All right. And sir, when you were working at Gracefield Corrections Institution, did you work with a Captain Matthew Sanders?
Yes, ma'am.
All right. And were you present on the prison grounds the day that Captain Sanders was injured?
Yes, ma'am.
Sir, can you tell us where you were at when Captain Sanders was injured?
I was coming out of Charlie unit because I was inside security, which is like basically a roaming officer. Now I was coming from Southgate. I seen Officer Dosick come out of Alpha with the inmate Joshua Lawson. I stepped across Northgate and I looked left towards food service for some reason, and then I looked right, and that's when I seen the inmate body slam Captain Sanders.
Okay. And by body slam Captain Sanders, can you give us a little more description about what you saw?
I seen
Like-
Captain Sanders like reach towards him, so I like lunge at him to grab him. I just seen the inmate literally like pick him up and just slam him, like body slam him.
Okay. Body slam him to the ground.
Yes, ma'am.
And did you have any, what happened after the captain was body slammed?
I ran towards to help, but the inmate ran towards me looking back, and then when he turned to see me, he dropped to the ground. So I got on him and cuffed him up.
Okay. And so you just happened to be heading in the right direction to kind of intercept inmate Lawson. Is that correct?
Correct.
Okay. Did you have any contact with Captain Sanders after that?
No, ma'am.
Okay. Once the inmate was cuffed up, where did you guys take him? Was
Well,
there like
normally
a
in
specific holding
situations-
place?
Yes, ma'am. Well, in situations when they're going to confinement, we normally take them to medical to get pre-confinement. But we went through the emergency door in medical, I think because they was working on the other door. And when we got in there, he became kind of erratic. So we took him straight to confinement and to the holding cell in the showers.
Okay. All right. Your Honor, at this time, I'll tender the witness.
Ms. Kelly, do you have any cross for this witness? And don't forget, he cannot hear you if you're not speaking into the mic.
Hi, Officer McCrary. Were you in a position to witness any of the lead up to what was going on here?
No, besides him coming out of the Alpha dorm where he was ousted.
Okay, so where were you kind of located in reference to the events that occurred?
As far as when he slammed Captain or when he was coming out of Alpha.
From the time that he gets to the captain's office, were you there with Officer Dosick and Mr. Lawson the entire time?
I wasn't physically next to them. I was literally maybe 30 feet, like looking towards him.
Okay. And then how long would you say this action occurred? It was seconds?
Yeah, it's probably maybe 15, 20 seconds, maybe 30.
Okay. And when you asked Mr. Lawson to get on the ground after this happened, did he comply?
I didn't ask him. He just looked at me and dropped.
Okay. But he immediately got on the ground?
Yes.
Okay. And had he been pepper sprayed?
No.
Okay. I don't have any more questions. Thank you.
Does the state have any redirect? And don't forget, he can't hear you if you don't speak into the
Yes,
mic.
Your
Yes.
Honor, a couple of questions. Officer McCrary, did you, when you came to the state attorney's office previously, did you watch a surveillance video of the incident?
Yes, ma'am.
Do you recall that? And did you
Yes.
initial the disc after you watched it?
Yes, ma'am.
Okay. And did that video accurately reflect what you saw happen in person?
Yes, ma'am.
Okay. Now, Officer McCrary, we can only kind of see like part of your upper body and your face, but you're a pretty big guy, right?
A little bit. I ain't too big, but I'm bigger than.
Okay. You might have played some college football and maybe a little bit of pro.
Yes, ma'am.
Okay. And so when you are coming towards the inmate Lawson, you don't even instruct him to get on the ground. He just gets on the ground.
Yes, ma'am.
I don't have any other questions, Your Honor.
Can I just one follow up?
Absolutely. Go ahead.
Thank you. Officer McCrary, about how tall would you say Mr. Lawson is?
I don't know off the top of my head. That was my first run-in with the inmate, so I really don't know. I know he wasn't taller than me. Maybe 5'8", maybe 5'7".
Okay. All right. If you don't recall, that's fine. Thank you.
Yes, ma'am.
Anything else from the state? Councils, may this witness be released? Officer McCrary, you are released from your trial subpoena. Thank you for joining us, and you are free to disconnect and go about your day.
Yes, ma'am. Thank you.
Thank you. Madam Clerk, if we could go to none and TVs. Thank you, ma'am. Does the state wish to call its next witness?
Certainly, Your Honor, and I've asked Mr. Gill to assist me in getting, I anticipate playing the video through this, but ask him to come in to help.
Absolutely. Fair enough. We all need tech support.
But yes, Your Honor, at this time, the state would call Inspector Julian Bass.
All right, Inspector Bassford. Inspector Bassford, good morning. Please raise your right hand so that you may be placed under oath by Madam Clerk. Inspector Bassford, both the chair and the microphone on the witness stand adjust. Please adjust them both so that you're able to speak loudly and clearly into the microphone. Ms. Jeffcoat, your witness.
Sir, can you please state your name for the record?
Yes, ma'am. Julian Grady Bassford, also known as Jerry Bassford.
All right. And sir, how are you employed?
I'm an inspector detective for the Florida Department of Corrections, Office of the Inspector General,
And how long have you been in that role?
since August of 2015.
And what are your duties as an inspector?
I'm a criminal investigator. I investigate criminal acts that occur within the Florida Department of Corrections.
And before becoming an inspector, what did you do for a living?
I was a deputy sheriff and investigator for the Jackson County Sheriff's Office, and prior to that, a police officer for Marion Police Department.
All right. And sir, did you investigate an incident that happened at Graceville CI on March the 18th of 2021?
Yes, ma'am.
What was the nature of that incident?
I received a report of a inmate on staff incident where a staff member was injured.
And how, oh, you received a report. Okay.
Yes.
Upon receiving that report, what did you do?
I went to Graceville. That was a particular call that we responded immediately to. I went there and initiated our investigation and conducted interviews and collected the evidence that was there.
All right. Did you interview the officers that were present during the incident?
Yes, ma'am.
Okay. And were their statements consistent?
Yes, ma'am.
Were you also able to obtain and review the surveillance video at the institution?
Yes, ma'am, I did.
And can you kind of describe the surveillance cameras there at the institution? Like, what are they, how are they positioned, things like that?
There are numerous cameras across the compound there that capture different angles. It's not all covered on video, but majority of that institution does have some sort of video coverage.
Okay. And those recordings, I guess they're always recording, correct?
Yes, ma'am.
All right. And when you got a copy of the surveillance from this particular incident, did it show what happened or the incident where the officer was injured?
Yes, ma'am.
Okay. And what was the officer that was injured? What was his name?
Captain Matthew Sanders.
All right.
Your Honor, may I approach?
Absolutely.
I'm going to show you what's been previously identified in State's Exhibit A. Can you look at that item and tell me if you recognize it?
Yes, ma'am.
And how do you recognize it?
My initials are on the front of it. That is the video of the incident.
All right. And there's some other initials on there of other officers that have reviewed it. Is that correct?
Yes, ma'am.
Your Honor, this time the state would like to offer, file, and introduce State's Exhibit A.
Is there any objection?
No, Your Honor.
Ladies and gentlemen of the jury, what's been marked for identification purposes as State's Exhibit A is now admitted into evidence as State's Exhibit A. Does the state wish to publish?
Yes, Your Honor.
Sure, take your time. And the state may publish. Madam Clerk, if you will please put prosecutor PC on TVs and on the TVs in addition to the Polycom.
And Your Honor, with the court's permission, I'll get the video queued up and then I'm going to turn over the mouse to the inspector.
You may. You may, and you may move about the courtroom if you wish. Yes, there's a sound associated. Is that right, State? Or no?
It's not audio.
Okay. Fair enough.
Video. Inspector Bassford, tell us kind of what all we're looking at. It looks like we have multiple little screens up.
Yes, ma'am. The top left camera angle is the Sally Port area of a dormitory. So is the one to the right. That is between the front door of a dormitory and another set of doors. That's entrance and exit into that dormitory.
Okay. And so the top left and top middle are both a dormitory. Is there a camera? Where are the cameras located in these images?
So those are opposing cameras showing two angles of the same area. The top left is looking towards the outside doors where the light is shining in.
Okay.
The top middle is looking inward toward the dormitory, and through the windows there, you can see the officer station that's in the center of that dormitory.
Okay, can you point to where with the mouse where the officer station is?
This white wall that you can see through the window
Ah.
is the officer station sitting in the middle of the 4 quads of that dormitory.
Okay, so basically in the top left and top middle, if I'm understanding you correctly, there's basically 2 cameras, one on each end of a sort of a hallway.
Yes, you would see if somebody was exiting the dorm, they would come through these doors, and as they disappeared from camera view here, they would be appearing here, headed out the front.
Okay. And then the bottom left, what area is that in?
The bottom left is what they call the north gate. It's the end of the sidewalk. The bottom right, or excuse me, bottom middle there is the north sidewalk. This is a dormitory.
Okay, that white building is a dormitory?
This white building is a dormitory. So these doors are the same doors that you see in this camera.
Okay,
So if somebody exited these doors, you would see them appear here
okay,
and come down this sidewalk. And as you came up north sidewalk, you would appear at this gate.
okay. And so essentially the camera angles are not in specific order necessarily of where we were watching it, but you've seen this many times. So can you kind of tell us the path of that we will be watching?
Yes, ma'am. So you'll first see the escort officer, Dosick and Mr. Lawson come out through these doors. You will see them come out the front door here. They will appear on the sidewalk outside of the dorm, follow the sidewalk up. There's a brief moment here that they may not be covered on video. They will appear on this sidewalk, and this is the program's sidewalk, which is this camera angle here. And North Gate is at the far end, kind of where my mouse is. There may be a small gap there of not covered.
Okay, that bottom left camera angle or screen, is that on the same sidewalk as the top right?
Yes, it is.
Okay, are they at opposing ends as well?
That's correct.
Okay. And then can you tell us if where the captain's office is?
The captain's office, and I will click on that one, make it a bit larger, is right in this area behind the title of it. And on this camera system, you can choose options to remove the overlays on it where you can see better.
Okay, so that where it says 78 programs exterior walkway, that's an overlay?
Yes, ma'am.
Okay, and I think part of our incident kind of happens where that overlay is. So can you deselect that so we'll be able to see what happens
Yes,
a little more
ma'am.
clearly? All right. And I have seen that you have enlarged, you can enlarge the screens.
Yes, ma'am.
And so when you play it, can you kind of enlarge each screen as we need to see it?
Yes, ma'am.
Okay. And sir, if you will kind of start with the first area where we will see inmate Lawson and start from there.
Okay.
All right. And
I'll
switch
put
to
it
the
down.
next, I guess, camera angle. And for the record, that was camera, I guess, number 92, is that correct? Is that how, or there's a 92 in the top right-hand corner? Is that in all
There's
of
a
them?
95 in both of them. I'd have to put the
Okay.
overlay back on it, but that was this middle. And they go back to the same order.
I'm sorry, okay, the
when
top middle.
the top middle.
Okay,
And you can see them here before I enlarge it. They've appeared on this camera now as they've made it out of this camera view.
which is the top left
The top,
video.
top
Okay.
left, yes, ma'am. And then they appear on the bottom middle.
Okay. And so we're playing bottom middle now, correct?
Yes, ma'am. as they exit view of the bottom middle, they should appear on the bottom left on this side of the screen.
Okay. Thank you, sir. So now playing bottom left.
And this gets in the area where some is more visible than others on the other camera angle.
Okay. And so now top right, correct?
Top right, yes. So that's the captain's office that Officer Dosick has walked up to.
Okay. All right. And sir, could you back it up just a little bit? I want to ask you about just before the captain comes out. All right, if you'll hit play again, sir. There's no audio in any of these, correct?
No, there are no audio recordings at this particular.
Okay. Now, at any point before the officer goes to, kind of reach for the inmate, we've heard some testimony that he was going to try to place him into handcuffs. Do you see any of the officers deploying any chemical agents or anything like that?
I do not.
Okay. If you could hit play again. All right. Now, sir, after the officer was injured, do you know if he went to the hospital?
Yes.
Okay. And ultimately, you did speak with him. I can't ask you what he told you because it's hearsay, but did you end up speaking with him after this incident?
Yes, I did a telephone interview with him after the incident.
Okay. And then you also interviewed the other officers that were present prior to the use of, or to the officer getting slammed to the ground, correct?
Yes, ma'am.
Now, at some point, did you learn of Captain Sanders passing?
Yes, ma'am.
And how were you notified of that?
The then Assistant Warden, Terry Dudley, called me and let me know that Captain Sanders had passed away.
Okay. And did you end up speaking with the, do you know if an autopsy was performed?
Yes, ma'am.
Okay. And where was the autopsy performed at?
At the medical examiner's office in Panama City.
Okay. And were you present for that autopsy?
Yes, ma'am.
And did you also speak with the medical examiner? And you can't tell us what he said, but did you speak with him?
Yes, ma'am.
And did he give you an opinion? Again, now he'll testify later, but did he give you an opinion about the cause of death?
Yes, ma'am.
And based on that, what did you do?
I completed a probable cause affidavit charging inmate Lawson with an open count of murder.
Your Honor, I'll tender the witness at this time.
Ms. Kelly,
Thank you, Your Honor.
your witness.
Thank you. Investigator Bassford, were you present for any of the incidents that occurred here?
No, ma'am.
So everything that you learned was through the course of speaking with witnesses after the fact?
Yes, ma'am.
Okay. And then later on, after the immediate incident here, were you present for any of the relevant factors or incidents that occurred?
As far as, could you ask that question again, please?
Were you at Captain Sanders' home?
No.
Okay. Did you go to any doctor or to Captain Sanders' doctor's appointments?
No, ma'am.
Did you speak with any of his doctors?
No, ma'am.
Okay, so the information that you gathered, and essentially your function was kind of gathering all the information and organizing it and making the case, right?
Yes, ma'am.
Okay, so all of the information you gathered was from outside parties.
Yes, ma'am.
Okay, I don't have any more questions. Thank you.
Anything further from the state? May this witness be released, or do you wish for this witness to remain subject to recall? All right, Investigator Bassford, you are not yet released from your trial subpoena and you do remain subject to recall.
Yes, ma'am.
All right. Ladies and gentlemen of the jury, this is a good place for us to take our mid-morning break. Please remember that you have not yet heard all the evidence, my instruction on the law, or the argument of the attorneys. Therefore, do not form any definite or fixed opinions regarding the merit of this case. We will have a little bit of a longer break, so you are welcome to speak to your family and friends about personal matters or whatever you wish, except do not speak to anyone or allow anyone to speak to you about this case. Please leave your notes and do not discuss the case amongst yourselves. Please leave your notes on your chairs and they will be guarded until it is time for you to come back. Everyone remain seated for our jurors to exit the courtroom. Chuck, they may walk about or remain in the room, whatever they prefer. Let the record reflect that the jurors have exited the courtroom. However, still present in the courtroom is counsel for the state, counsel for the defendant, and the defendant. Counsels, how are we coming with Dr. Radke? I know he's coming from Panama City, but how are we coming? Rory, what you
I
know?
spoke with the investigator Whit Majors on the phone at 9:45. He stepped in and talked with the doc. He was gonna put on his jacket, and come this way immediately, so it's driving time from his office in Panama City to the courthouse.
So maybe by the end of the break, he'll be able to testify. Maybe. We can start doing some. It's okay, but I don't think waiting till 2 was, I didn't want to wait till 2, obviously. I mean, it's just too much time to ask the jurors to wait. Okay. All right, Jeannie, could we take prosecutor PC off of the TVs and go back to camera quad to the Polycom? So camera quad for the Polycom, none for the TVs. Excellent, thank you. All right, so that is anticipated to be the last state witness.
Yes, Your Honor, and I do anticipate that there will be 7 photos shown during Dr. Radke's testimony.
Okay,
And I know that there are some.
Lawrence, move the mic for, thanks. Go ahead.
I do anticipate 7 photos to be shown during Dr. Radke's testimony. Those were photos that Dr. Radke picked that would best help him explain victims' injuries to the jury. I do know they could be distressing to friends and family member in the courtroom, so I just wanted to let the court know and as well as the audience know that
Sure.
that those could be available.
So for those friends and family members that we have in the courtroom, please know that you may remain in the courtroom while those photographs are coming up. If at some point during those photographs it becomes uncomfortable, then I am happy for you to quietly walk out as long as you are not disrupting the work of the jurors during that process. Or if you wish to simply remain outside of the courtroom while Dr. Radke testifies, then you may make that decision as well. But that choice is yours. Do you want to, why don't we take a break? Then we'll come back and we will begin discussing jury instructions preliminarily as we wait on Dr. Radke to arrive. Okay. And then we'll have any motions and whatnot. Okay. Thanks, guys. We'll be in recess.
Yeah, it's just moving. I anticipated more like side doors and stuff. Thank you. I don't know why it worked automatically. Normally I have to do something to make it work and it did not, I didn't need the thing.
All right, we're back on the record in Jackson County, case number 21 CF 610. Today's date is June the 25th, 2024. The time is 11:15 a.m. Present in the courtroom is counsel for the state, counsel for the defendant, and the defendant. The jurors are not yet present in the courtroom. Ms. Jeffcoat, officially, we anticipate that the state's last witness, Dr. Radke, is almost at the courthouse. Is that right?
That is correct, Your Honor, except the state does intend to briefly recall Inspector Bassford.
All right, fair enough. Ms. Kelly, we had some discussions off the record regarding whether or not you would be allowed to inquire regarding Gregory Dosick and some offense that you believed may have had him terminated. Have you had sufficient time to speak to your client regarding this issue?
Yes, Your Honor. I had initially believed that there would be an argument as to bias involving Officer Dosick and Mr. Lawson, but after speaking with Mr. Lawson, he does not believe that there was any bias on Dosick's part towards him. So,
All right, Mr. Lawson, if you will raise your right hand, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth? All right. Do you need any more time? You can put your hand down, sir. Do you need any additional time to speak to your attorney about that issue?
No.
All right, fair enough. So you don't intend to recall him, at least as of now. Certainly, if you choose to, then I'm happy for you to do so.
not at this time, Your Honor.
All right, fair enough. So while we have some time, let's continue. See here? Okay. Let's go ahead and bring the jurors in then, and you can call whatever witness you wish to call next, Ms. Jeffcoat.
Yes,
And
Your Honor. Can I
then,
just have a
go ahead.
second just to let him know?
come on up, Dr. Radke. Dr. Radke, if you'll stand next to the witness stand, we're going to place you under oath as soon as the jurors come out. All right. Any reason why we can't bring the jurors in, counsels?
Yes, Your Honor.
All right. We're going to remain seated for the juror. Actually, just have a seat, Dr. Radke. We're going to remain seated for the jurors to come in. Let's bring them on in.
Jury in the courtroom.
Welcome back, ladies and gentlemen. Is the state ready to call its next witness?
Yes, Your Honor. The state would call Dr. Radke.
All right. Dr. Radke, hello. If you will please stand and raise your right hand for Madam Clerk to place you under oath. Dr. Radke, the chair and the microphone both adjust. Please adjust them both so that you're able to speak loudly and clearly into the microphone. Ms. Jeffcoat, your witness.
Thank you, Your Honor. Morning, sir. Can you please state your name for the record?
J. Michael Radke.
And sir, what is your occupation?
I'm the District 14 medical examiner.
And how long have you been working in that role, sir?
9 years now.
Describe your education and your training for you to fill that role.
I have an undergraduate degree from Florida International University. I have my doctorate in medicine from Central Caribbean University. After that, I did a 4-year residency in pathology at Jackson Memorial Hospital in Miami-Dade County. Following that, I did a 1-year fellowship in forensic pathology. After that, I sat for my boards and got board certified in anatomic and forensic pathology.
And sir, have you, you said you've been working with the 14th Circuit Medical Examiner's Office or as the medical examiner for how long?
9 years.
9 years. And then before that, you worked for some other medical examiner's offices.
Correct. I was a medical examiner in Miami-Dade.
And sir, have you previously testified in court as an expert?
Yes.
And in what?
Forensic pathology.
Forensic pathology. And can you tell us what is forensic pathology?
So pathology is what they do in the hospitals when they diagnose tumors, when they do all the labs, like do a CBC and stuff. And then forensic pathology is just specifically in how people die and the medical legal aspect of it.
Right. And sir, approximately how many times have you testified as an expert in that field?
Probably over 50.
Sir, can you tell me if you performed an autopsy on a gentleman named Matthew Sanders?
Yes.
And what was the date of that autopsy?
I believe it was the 8th of April, 2021.
And were you able to determine a cause of death?
Yes.
And what was that?
It was pulmonary saddle embolism due to deep venous thrombosis, due to a complication of a right femur fracture due to a physical assault.
Right. And what was the manner of death, sir?
Homicide.
What was that?
That the death resulted because of an intentional action by someone else.
All right. And so let's go back to the cause of death. Can you kind of describe that some more to the jury, what a pulmonary saddle is?
So you have a large vessel that leaves your heart and takes the blood to your lungs to get the oxygen. And a saddle embolism is a blood clot that blocks that artery off so it can't get blood to your lungs. So it basically stops all the blood. It's like putting a plug that'll stop all the blood going to your lungs.
And sir, when you perform an autopsy, do you take photos during that process?
Yes, we do.
And were photos taken during the autopsy of Matthew Sanders?
Yes, they were.
Were there any photos that you selected that would help you describe the injuries sustained by Mr. Sanders as well as the ultimate cause of death?
Yes.
You may.
Sir, I'm going to show you what's been marked as State's Exhibit B1 through 7. If you look through those, you can correct them. Okay, and how do you recognize these, sir?
They're photos from my autopsy.
Okay, and it looks like you have a unique autopsy number in some of the photos. Is that correct, sir?
Yes, everyone gets a case number.
Your Honor, at this time, we would like to offer file and introduce State's Exhibit B1 through B7.
Is there any objection?
No, Your Honor.
What's been marked for identification purposes as the state's exhibits B1 through B7 shall now be admitted into evidence as state's exhibits B1 through B7, and these will be available to you during your deliberations.
Your Honor, may we publish at this time?
You may. Madam Clerk, if you will please put prosecutor PC on the TVs, and as long as we still have camera quad on Polycom.
All right, sir, I'm going to give you the mouse.
Okay.
It has a little pointer on it that might help you with the process, and I'll advance it.
Okay.
I'm going to go first to State's Exhibit B1. And what are we looking at in this photo here, sir?
So this is a photo of the decedent as how we received him into the morgue with his clothes and all.
All right. And who do the funeral homes transport the when somebody has died outside of a hospital? They sometimes transport them to the autopsy to the medical examiner's office.
Many times it's a funeral home, or we also have a transportation service.
Okay. And State's Exhibit B2.
This is showing his right thigh, and then right here and right here are where he had his surgery to repair his broken femur that was underneath here.
Okay. And so those are basically like surgical scars or surgical injury sites?
Yeah, so this is where the surgery is still healing up from where he had it.
Okay. Now going to State's Exhibit B3, sir, what are we looking at here?
So I've opened up his chest, and I'm lifting up one of his lungs in my hands right here. And then that's the airway. And then I'm showing underneath the airway right here, this red, white area, that's that blood clot that's blocking off, coming out of the heart and blocking off that vessel to the lung.
Okay. And I think we have another image of that. Your State's Exhibit B4, sir, what are we looking at here?
So that's that clot that I just showed, and I'm grabbing it with the forceps, and you can see that it's blocking off that whole area and how firm it is.
And State's Exhibit B5?
So this is the clot after I removed the whole thing. So this was going into both sides of both lungs. And so you can see this is a large clot in the shape of that airway, in the shape of a vessel, excuse me, and how it broke off.
And so this is after it's actually been pulled out of the artery.
Correct. That's after taking the whole thing out of the lung.
And so State's Exhibit B6?
So now I'm looking in the back of the right leg, the leg that had the surgery. And there's a blood vessel right here. And that's a vein that has a little bit of clot left. And there's another vein down here that also has some clot left. And that's in the back of the leg where those clots started.
Okay. And so the clots would have started, and is that the leg where he had the surgery?
Yes, it is.
Okay. And so the clot would have started in the leg and then traveled up to where you were eventually removed it from chest?
Correct. So the clot would have been there, and then it would have broken off, and that whole thing would have gone through the system, like going through a tube or down a drain, and then until it ended up where it couldn't go any further, which was the lungs.
And now looking at State's Exhibit B7, sir.
So now I'm taking all the muscle and the skin off the leg and reflected back, and that's that fracture line right here that was previously repaired. You can see there's a little, very thin line that went through the bone right there.
And the cause of death, pulmonary embolism, is that a known complication for hip fractures?
Yes, it's one of the most common complications.
How frequently might that be seen?
It's generally seen in at least around, different studies are different, but in 1% of all people who have hip fractures, so 1 out of 100 people will end up having a pulmonary embolism.
Okay, so 1 out of 100 people that have a hip fracture will have a pulmonary embolism.
That's correct.
Does the defense wish to cross-examine this witness?
Yes, Your Honor.
Ms. Kelly, your witness.
Thank you, Your Honor.
Your Honor, I'm going to take that.
Yes, you may. And Madam Clerk, if you will put none TVs. Thank you. Ms. Kelly?
Thank you, Your Honor. Dr. Radke, your residency was in pathology, I think you stated.
Yes, that's correct.
Okay. And so pathology, do you normally treat patients while you're doing that, or is it mostly examining specimens, things of that nature?
There's some of both. We have rotations where we treat patients and like transfusion medicine where we get blood products, but then there's also a lot of specimens and laboratory samples.
Okay. And since residency, and have you had treated any patients since then?
Sporadically.
Okay, but it's not something that you do normally within the normal course of your profession?
Correct.
Okay. Do you have any sort of specialty in endocrinology?
No, I don't.
Okay, how about hematology?
I studied hematology because it's part of pathology.
Okay, so is that something that you do fairly often in living patients, I guess I should?
No, but sometimes, we'll end up diagnosing like bloodborne cancers, different kinds of coagulopathies and things like that in postmortems.
Okay, how about pulmonology?
No.
Cardiology?
Just in the cardiac pathology aspect of it, not the like giving drugs or treating somebody with heart disease.
Okay, orthopedic surgery?
No.
Okay. In performing this autopsy or preparing for trial today, have you reviewed any of Captain Sanders' previous medical records?
Most likely I did, yes.
Okay, just since the surgery occurred or throughout the course of his medical history, say within the last year to 5 years?
I don't have a specific recollection of exactly what medical records I reviewed.
Okay. Did you speak with any of his treating physicians after the surgery?
I don't believe so.
Okay. So there are other things that can cause blood clots besides surgery, right?
Yes,
Okay. Those include things like immobility,
correct.
a family history of blood clots.
If someone has a genetic disorder that would predispose them to something like that.
Okay. Age.
Not necessarily. It has mostly to do with the age-related immobility.
Okay. Obesity.
Yes, also related to immobility.
Okay. Smoking.
Yes.
Previous cancer treatments.
Yes, also.
Okay. Hormonal therapies.
Some of them, yes.
Heart disease or high blood pressure.
Generally don't cause pulmonary emboli.
Okay. Heart disease is not associated with pulmonary emboli or blood clots.
They're separate things. So I would say high blood pressure is generally not so you generally don't see people die of blood clots who just have high blood pressure.
Okay. How about lung disease?
Well, a pulmonary embolism would be associated with a lung problem. Some chronic inflammation in the lung can also cause it.
Okay. Inflammatory bowel disease,
Rarely.
dehydration.
Usually that'll go to obesity, immobility, and a spectrum of things like that
Okay. Circulatory issues.
as well.
Okay. Is diabetes associated with circulatory issues?
Yes.
What are some symptoms of blood clots? What's something to look out that it's coming?
A lot of times there'll be pain or swelling in the legs, heat or warmth, redness in the legs if it's a leg blood clot. And then if it breaks loose, it's shortness of breath a lot of times or sudden death.
Okay. How about coughing up blood?
It can be, but that's a non-diagnostic sign.
Okay. Chest pains?
That would go with the shortness of breath most likely.
Shortness of breath, dizziness?
Yes, when the blood can't get there because of the air.
All right. Do you know there anything that can be done to prevent blood clots post surgery, like blood thinners, things like that?
Generally, I don't treat people after surgery, but I know there are lots of different things that they do for people in surgery.
Okay. What things are you familiar with?
Your Honor, I'm going to object. I think this is outside the scope of the witness's expertise.
Overruled. I'll allow it.
Thank you.
They can give them like anticoagulants. Sometimes they do rehab where they do rehab things in rehab. They can put like pressure sleeves on their legs. I mean, those are some of the things I know about, but I'm sure there's a lot of other things that I have no idea.
Okay. Do you know if they ever do any sort of internal filters within veins or arteries in the body?
Yeah, sometimes they do that, but I believe that's generally after someone's already had a big clot. But like I said, I don't put those in people, so I don't know.
Did you find any evidence of one of those in Captain Sanders?
No.
Okay. Did you review what medications he was on other than analgesics after the surgery?
I reviewed his medical record, but I don't specifically remember what the medications were.
Okay. When you reviewed his medical records, did you look at any of those other factors that we talked about in blood clots? If he had COVID?
Like I said, I don't recall exactly what else I read in the records.
Okay, so you don't recall, other than him having surgery, you don't recall the content of any of them?
No, not specifically.
Okay. How tall was Mr. Captain Sanders?
I believe he was 6'2".
Okay, and about how much did he weigh? Do you recall?
I can refresh my memory with my notes. 219 pounds.
Okay, all right, that's all I have. Thank you.
Does the state wish to redirect
Yes, Your Honor.
your witness?
Dr. Ackley, ultimately, Captain Sanders died as a result of a blood clot in his lung, correct?
Yes,
And that blood clot, if I understand your testimony correctly, originated from a broken femur.
that's correct.
So the broken, whether or not he was diabetic or had smoked in the past, that didn't cause the blood clot, correct?
I mean, it could have increased his risk factors, but having the immobility of having the broken leg and not moving and is what caused it.
Okay. And you found evidence when you performed the autopsy that the blood clot had actually originated from the area of the broken femur, correct?
Yes, correct.
No other questions, Your Honor.
Anything further from the defense?
No, Your Honor.
May this witness be released, counsels?
You may, Your Honor.
Defense? All right, Dr. Radke, you are released from your trial subpoena and may leave the courthouse. Does the state wish to call any additional witnesses?
Your Honor, we just would like to recall very briefly Inspector Bassford, and it
All right.
shouldn't be more than a few questions.
Sure, Inspector Bassford.
Inspector Bashford.
Inspector Bassford, you remain under oath. Please speak loudly and clearly into the microphone. No need to place you under oath again. Ms. Jeffcoat, your witness.
Thank you, Your Honor. Inspector Bassford, the incident where we watched the video where Captain Sanders was thrown to the ground,
Yes, ma'am.
that happened on Graceville CI campus, correct? The
Yes,
FD
ma'am.
Institute. Is that, what county is that located in?
Jackson.
Jackson County. All right, thank you. I have no other questions, Your Honor.
Does the defense wish to cross-examine this witness?
No, Your Honor.
All right, Inspector Bassford, you're still subject to recall on your subpoena. All right, ladies and gentlemen of the jury, this is a good time for us to take our lunch break. The time is 11:34. We will continue to do some work while you guys take a lunch, and I need to give my staff an hour lunch break. So I'm going to ask that you guys come back at 1. And that'll be about an hour and 25-minute lunch break. And at that time, we will resume the trial. Please remember, you may not have yet heard all of the evidence. You have certainly not heard the attorney's arguments or my instruction in the law. Please do not form any definite or fixed opinions regarding this case until such time, and do not speak about the case either among yourselves or with anyone else. And we will let you go to lunch, and we'll see you guys back at 1 o'clock. Thank you very much. Let the record reflect that the jurors have exited the courtroom. The state is still present. Counsel for the state, counsel for the defendant, and the defendant are still present in the courtroom. The state has now rested. Is there anything from the defense at this time?
Yes, Your Honor, at this time, we would move for a judgment of acquittal. Based on the nature of the offenses, the state has to prove that the defendant's conduct rose to the level of culpable negligence at the very least, and we don't believe that the state has proven that at this point, so we would move for judgment.
All right. Response from the state.
Your Honor, the evidence viewed in the light most favorable to the state shows that the defendant picked up Captain Sanford, threw him to the ground. As a result, Captain Sanford's was injured, that it was a serious injury requiring surgery, and included a fractured femur, that ultimately a blood clot developed in the location of the fracture and traveled to his lung, which ultimately killed him. With that, Your Honor, the state believes that the evidence is sufficient to go to the jury for this offense and all the lesser included.
The court is reviewing the proposed instruction for aggravated manslaughter. In that proposed instruction, the court, considering the evidence in the light most favorable to the state, must consider whether or not there's sufficient evidence for this jury to make this determination as to whether or not the defendant is guilty of this offense. One, the state would have to prove that Matthew Sanders is deceased, and that has been testimony provided by both his wife and Dr. Radke. Two, that the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. The court has heard testimony that in March, Joshua Lawson picked up Mr. Sanders and threw him over his shoulder, breaking his femur, and has seen video to that effect. The court has also heard testimony by Dr. Radke, where Dr. Radke opines that the decedent's cause of death is a blood clot in the lung that originated from the broken femur and the resulting immobility from that leg. The state would also have to prove that at the time, Matthew Sanders was an officer who was at the time performing his duties within the course of his employment. And certainly there has been the testimony of numerous witnesses that at the time of the incident between the defendant and Matthew Sanders, that Officer Sanders was acting as captain. That's the reason the inmate was taken to the decedent. because he was the captain and that was the next in the chain of command. The instruction on culpable negligence indicates that culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily harm, even assuming that the defendant wouldn't have known that this was likely to cause death. Swinging someone over your shoulder, and body slamming them onto a concrete floor would certainly be conduct that should reasonably be known to cause great bodily harm. And accordingly, the court finds that there is sufficient evidence for this matter to go forward to a jury. And so the motion for JOA is denied at this time. Mr. Lawson, I've already placed you under oath, and I'm going to go through a colloquy with you, but I don't want you to tell me your final decision yet, okay? Because I want you to have more time or as much time as you need to speak to your attorney about this. Mr. Lawson, in any criminal trial, a defendant has the absolute right to remain silent. Do you understand that you have that right?
Yes, ma'am.
All right. If you choose to remain silent, I will instruct the jury not to hold that against you, just like I instructed them not to hold it against you in the beginning of this trial. Do you understand that?
Yes, ma'am.
You can testify if you wish. However, if you choose not to, you can testify if you wish. However, if you choose to testify, your testimony will be considered just like anyone else's. Do you understand that?
Yes, ma'am.
The state will be able to cross-examine you, just like the defense has been able to cross-examine all of the state witnesses. Do you understand that? The state will be able to ask you whether or not you are a convicted felon. And because you were in state prison, it's my understanding that you are a convicted felon. And that testimony would go towards your credibility, any prior felony convictions or misdemeanor crimes of dishonesty. Do you understand that? All right. Your attorney can give you advice regarding whether or not she thinks that you should testify. However, I need you to know that the decision whether or not to testify is ultimately your own. And even if your attorney says you shouldn't testify, if you want to testify, you can. Do you understand that?
Yes, ma'am.
All right. So during the lunch break, I want you to speak to your attorney about whether or not you wish to testify. And at the end of that break, I'm going to ask you whether or not you've had enough time to talk to her and what your decision is. Okay?
Yes, ma'am.
Ms. Kelly, certainly not going to hold you to this, but do you anticipate any defense witnesses?
At our last conversation, Mr. Lawson indicated that he did believe he would testify in his own defense, and
Fair enough.
that would be
One.
sole defense witness.
The sole defense witness. Fair enough. Okay. So anticipating that, is there any reason we can't do a little bit of charging conference? Obviously, we will amend the charging conference. The final charging conference will occur after Mr. Lawson has decided whether or not he wishes to testify. But most importantly, I want to talk about the lessers. Okay. Any concerns on the introduction to homicide? Can I get these in digital form too?
Yes, Your Honor, I
Sure.
can, do you want me to email them to Ms. Birch, or do you want me to just pull them up on the screen?
No, you can, it doesn't have to be right now. We can email them to Ms. Birch and Ms. Kelly, and that way I can have digital copies too.
Sure, Judge.
Anything on the introduction to homicide instruction right now?
No, Your Honor.
All right, and then, so the crime charge is aggravated manslaughter. And is there no break in the culpable negligence on the standard? It just seems like a really long paragraph, but
I'll double check, Your Honor. I think I always try to copy everything directly. from
Sure.
the course
I went
before
through
it goes
line by
to-
line, and I think it's pretty much,
there's no break in the paragraphs? Okay, fair enough. And then the lessers that you guys have proposed are manslaughter, aggravated battery of an officer, culpable negligence, felony battery, battery on a law enforcement officer, battery, and culpable negligence. Is that right?
Yes.
All right. Is the defense asking for all of those instructions?
yes, Your Honor, I think culpable negligence is the category 1, and we had asked for the remainder is category 2.
Let me look.
Your Honor, for aggravated manslaughter, and culpable negligence are both category 1 lessers. The remaining lessers are by case law, and I can give you a case site that helps.
So manslaughter and culpable negligence are category 1 to which the defendant is entitled.
Correct.
And the category 2s only come in if there's sufficient evidence to support those category 2s.
That is true, Your Honor, but I think I got kicked off of stack. Let me see if I can go back to it. But the standard jury instruction for aggravated manslaughter doesn't list any category 2s. All of those aggravated battery, felony battery, battery on a Leo, those are all by statute or by case law. But
Okay.
I can provide you a site.
Do you dispute that that's appropriate?
Oh, no, I don't dispute that that's appropriate. I mean, it says that they're entitled to it. Or that the state and defense can be entitled to those, but
All right, so like when they're lesser included crimes or attempts, that's all bold. Whereas ag manslaughter is not, so we need to make sure we change that, or at least it looks all bold. So ag manslaughter looks different than introduction to homicide and when they're lesser included. We just need to make sure we take out the bolds or leave the bolds, but everything's got to be the same.
okay, I will,
Does that make sense?
sure.
Do you see how ag manslaughter looks different than all the others?
Yeah, it looks lighter than.
Yeah.
I don't know. I think when there are lessers, actually looks bolder than ag manslaughter or manslaughter. So I think that might be the part. Right now, but I'll check and make sure they're
Yeah.
all the same.
I think it's a different font.
It might be, yeah.
All right, so Ms. Kelly, you want all of those on there, correct? All right, so then we've got the manslaughter, ag battery on a law enforcement officer, and let me look, on manslaughter, 1, the decedent is dead, 2, that the defendant intentionally committed an act or acts that caused the death of Matthew Sanders, or the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. I think there's sufficient evidence on that. Aggravated battery on a law enforcement officer, 1. Joshua Lawson struck Matthew Sanders against his will. In committing the battery, intentionally or knowingly caused great bodily harm to Matthew Sanders. 3, Matthew Sanders was an officer. 4, Joshua Lawson knew Matthew Sanders was a law enforcement officer. And 5, Matthew Sanders was engaged in the lawful performance of his duties when the battery was committed against him. I think there's evidence of all of that, even without the defendant testifying. As to felony battery, there's 2 elements. 1, Joshua Lawson intentionally touched or struck Matthew Sanders against his will. And 2, Joshua Lawson caused Matthew Sanders great bodily harm, permanent disability, or permanent disfigurement. I think there's sufficient evidence for that to go to the jury. Battery on a law enforcement officer requires 4 elements. Again, intentionally touched or struck. 2, the decedent was a law enforcement officer. 3, defendant knew decedent was a law enforcement officer. And 4, Matthew Sanders was engaged in the lawful performance of his duties when the battery was committed. I think there's sufficient evidence for that. Battery, Joshua Lawson actually and intentionally touched or struck Matthew Sanders against his will. Certainly, there's enough evidence there. And culpable negligence. To prove the culpable negligence, we need 2 elements. 1, Josh Lawson inflicted actual injury on Matthew Sanders, and 2, he did so through culpable negligence. And the definition of culpable negligence there is a little bit different than the definition of culpable negligence in aggravated manslaughter, right?
I think the one in aggravated manslaughter adds a little bit to it because I was going through. So I think the first several sentences, first, I was cutting and pasting and comparing and contrasting, and there are some slight differences in them, but this is the standard jury instruction for culpable negligence. And then the one for aggravated manslaughter has a couple of additional sentences based on the standard.
Okay, fair enough. And then the others seem to be standard, and we'll address those individually once all the evidence has been presented. Anything else preliminarily that we need to look at on the proposed jury instructions?
No, Your Honor.
Anything from the defense?
No, Your Honor.
Do we have a verdict form yet? Or you can email that to me. Email that to me, and then we'll get a good, clean copy of everything once we're all done. All right, then let's be in recess. Let's come back at 55 after. So 12:55. The time is now 11:50. That way everyone gets a full hour lunch break, and then we'll be here a little bit before the jurors so that we can get started right at 1.
The only thing on the culpable negligence instruction, there's a extra sentence that says actual injury is not required that I left in. It is part of the standard instruction, but it says if 1A is alleged and the state's alleged 1B, because 1A is instead of inflicted actual injury is exposed the victim to personal injury. And so I would just propose that I remove that sentence, but.
Are you in a position to discuss that now, or do you want some time to think about it during lunch and then look at it and then tell me?
And that's just for the misdemeanor culpable negligence.
It was removing the sentence that says actual injury is not required.
Yeah, because in the italics above it, it says give if 1A alleged, and 1A would say that the defendant exposed the victim to personal injury rather than 1B, which is what I have in there, which is the defendant inflicted actual injury on the victim.
I don't have an objection to removing that sentence.
Fair enough. Then that will be changed on the proposed jury instruction. All right. See you guys at 12:55. We'll be in recess. Shut down. Thank you guys for, can we go off the record? Jeannie? Thank you guys for getting Radke here sooner.
Yeah, I
And chocolate bars. eat.
You can do what?
I can't eat a lot when during this, so I just went and
Oh,
got
sure.
a bottle of water from those little kind bars at McCoy's and
I used to not eat at all, but now I feel like I need to regulate my blood sugar more. So even a sandwich, you need half of my sandwich.
Some might help.
Have some protein or something.
during that trial with Bill,
All right, we are back on the record in Jackson County case number 21 CF 610. This is the case of the state of Florida versus Joshua Lawson. Present in the courtroom is counsel for the state, counsel for the defendant, and the defendant. The jurors are not present in the courtroom. However, the jurors are back from the lunch break. Mr. Lawson, before we went on the lunch break, we went through a colloquy regarding your right to decide whether or not you wish to testify. Do you remember that colloquy?
Yes, ma'am.
During the lunch break, have you had enough opportunity to speak with your attorney regarding your decision to testify?
Yes, ma'am.
Yes. And since that time, then, have you made a decision?
Yes, ma'am.
And what is your decision?
My decision is, I would
I can't hear you.
I would like to.
You would like to testify?
Yes, ma'am.
All right, fair enough. Before we bring the jurors in, what are the number of felony convictions and misdemeanor crimes of dishonesty?
He already has 4 felony convictions.
Does the defense agree? So, Mr. Lawson, what that means is that one of the attorneys is going to ask you how many times you've been convicted of a felony. If you say 4, as everyone agrees, then they can't go into anything further. But if you say something different, then they will go into the facts of those convictions, okay?
Yes, ma'am.
All right, why don't you come on up to the witness stand before we have the jurors come in? And counsel will take a very brief recess at the end, then the defense can, make any motions that they wish to make. And then we'll come back for closings.
Your Honor, just for the court's awareness, at some point I will ask that Mr. Lawson briefly stand up just so we can say hi.
Sure, and he is not bolted on the witness stand, correct? All right, fair enough. I have no problems with that. And so because Dr. Radke was sitting on the witness stand and I asked him to stand to be placed under oath, I'm going to do the exact same thing with Mr. Lawson. Mr. Lawson, I'm going to ask you to stand up to be placed under oath. Even though I've already placed you under oath earlier, I'm going to ask the clerk to do that after the jurors get here, okay? So for now, have a seat and then I'll tell you when to get up. You speak very softly, Mr. Lawson. It's important you talk loudly into the microphone, otherwise the jurors will not hear you, okay? So keep that in mind. Yeah, you can approach to adjust, and he can adjust too, because you can adjust that, okay?
Does he have cuffs?
No,
Okay.
he's not cuffed. So, yeah, you can use your hands and adjust the mic, okay? All right, any reason that the jurors should not be allowed to come in?
Nothing from the state, Your Honor.
No, Your Honor.
All right, or do not rise for the jurors to enter. Habits die hard. James, go ahead and bring the jurors.
Jury in the courtroom.
Welcome back, ladies and gentlemen. Please be seated. The state has rested its case. Does the defense wish to present any testimony?
Yes, Your Honor, this time the defense would call defendant Joshua Lawson.
All right. Mr. Lawson, if you will, please stand to be placed under oath by Madam Clerk. Please raise your right hand. Mr. Lawson, both the chair and the microphone adjust. Please adjust them so that you're able to speak loudly and clearly into the microphone, okay? You may have a seat. Ms. Kelly, your witness.
Thank you, Your Honor. Can you state your full name?
And I would encourage you to move your mic as well.
I apologize.
It's okay.
Can you state your first and last name for me?
It is Joshua Jamal Lawson,
Okay, what's your date of birth?
11/7/1995.
Okay, how old are you?
I'm 28.
28? Okay. So I'm just going to cut to the chase. When this incident occurred, you were an inmate at Graceville Correctional Facility, correct?
Correct.
Okay, so it's fair to say that you're a convicted felon.
Correct.
Okay, how many felonies have you been convicted of?
4.
Okay. And those were all, you were sentenced to those all on the same day? They were part of the same plea agreement?
Yes, ma'am.
So you saw the video that we saw earlier that was shown to the jury?
Right.
Okay. Prior to you being, you walking from your cell to Captain Sanders' office, had you ever met Captain Sanders before?
No, ma'am.
Right. Did you have any sort of animosity towards Captain Sanders?
No, ma'am.
Okay. Did you intend to hurt Captain Sanders at any point?
No, ma'am.
Okay. Kind of what as you were going up there, kind of what led to this to you go into Captain Sanders' office?
What led to originally was I was in the dorms. I was in the dorm and I was having my moment and I was using numerology. And
Mr. Lawson, I'm having trouble hearing you. Can you move the mic so that it's in front of you? And that way, when you're looking at Ms. Kelly,
Yes, ma'am.
Perfect. Thank you.
So I was in the dorm, I was messing with numerology, and I was in the dorm, I was writing down numerology and studying it.
What is numerology?
Numerology is the study of numbers
Okay, so you were writing down numbers and studying them?
and studying them. And I end up putting letterology with it also.
All right,
I end up putting letterology with it also.
numerology and letterology?
Right.
You can pull it. It'll pull more. All right.
Right. Right. All right.
So you were studying numerology and letterology?
Yes, ma'am.
So you were just in your dorm and you were doing that?
Right.
Okay, so what happened from there?
So from there, the officer was doing his routine rounds. And then after that, he come in the dormitory and Officer Dosette.
Gentleman we saw earlier today?
Yes. Ma'am. So after that happened, he comes in the dorm and he said, "Hey, what's wrong with you?" I say nothing. And I turned to go because I was snapping into the atmosphere of the dormitory.
We're just kind of talking out to
Right.
to the atmosphere?
Right. And he said, "Hey, I'm talking to you." I would turn around and go to my dorm, to the quad. Like, I'm already in the quad. Like they say, it was a quad, and then it's cell, initial cells. So I turn around and go to the cell, and he say, "Hey, I'm talking." So when he say that, I turn around and say, "Well, I'm not doing anything. I'm not hurting nobody. I ain't doing nothing to nobody." He just sat there and stayed there for 15 seconds. And then after that, his walkie-talkie go like static. And he asked me, "Oh, the captain want to speak to you." I'm like, "I didn't hear that over the walkie-talkie." So when that happened, no, ma'am.
Had there been any discussion of the captain wanting to speak to you?
No, ma'am.
Right, so he, Lieutenant Dosek indicated the captain wanted to speak to you.
Right. And then after that, he sat there for 15 minutes, 15 seconds, excuse me. I'm sorry, for 15 seconds. And he said, "You want to go speak to the captain?" I said, "Well, sure, let's go." You know what I'm saying? And that's when he stated prior, when he said I had the pen. So when we go to the captain's office, we get there, he asked for the pen. Right. Officer Dosek asked for the pen. When he asked for the pen, I told him no. And then when I told him no, so you're not gonna get him a pen. I refused, and then I opened the back of the pen, the pen cap. I took the pen cap off. I closed the pen up, and I gave it to him. When I gave it to him, he went in there 4 or 5 times to go see to the captain, to come speak with me, because he said he was dealing with a religious inmate, like he said previously stated. So when that happened, the captain come out. He go to adjust his belt, and when he adjusts his belt, he come into my section, my personal area, and he's like, "Turn around, cover up." And then I'm like, "No, can you please let me know what I'm being pre-confinement for, so I can be able to write what I need to write, so I can be able to come out of confinement after pre-confinement."
So you were, correct me if I'm wrong at this point, and just for clarification, because I think it's a little hard to hear you. You were in your cell, just writing down numbers and letters.
Right.
Right, and Officer Dosek told you that the captain wanted to speak to you.
Right.
Right, and you went to the captain's office.
Right.
Okay, and then Lieutenant Dosek asked for your pen. You hesitated at first.
Right.
But you gave it to him.
Right.
Then he went into the captain's office.
Correct.
And the captain, after going back and forth, the captain came out.
Correct.
Okay, and then at that point, you said the captain came out and kind of was adjusting his belt.
Correct.
Okay. And
Correct.
kind of coming towards you.
Correct.
Right. And then at that point, did you go towards the captain or did you back up?
I backed up.
Okay. So kind of walk me through.
So after the captain come out, he adjusted his belt, so he got a little closer. When he get a little closer, I backed up and I hit the gate. When I hit the gate, I do hands gestures. "Can you please let me know what I'm being locked up for?" And all of a sudden, his glasses fly off his face. So I'm looking like, "Whoa, I ain't do nothing. I ain't touch him." You know what I'm saying? So with that being said, my reaction is I'm stuck. He's stuck, and Officer Dosek is stuck. Now we're there like for 15 seconds, and when that happened, something just came over me, and I picked him up. Officer Sanders, I picked him up and placed him on his right side. So when I put him on the right side, he went to roll around on the ground. When he rolled on the ground, Officer Dosek told him, "Don't get up, don't move." You know what I'm saying? And then that's when I got sprayed. And when I got sprayed, I went straight to the ground.
How tall are you?
I'm only 5'5".
Okay. How much do you weigh?
like 140 or 149 right now.
Can you stand up for the jury?
Yes, ma'am.
Can you take your top off?
Yes.
Right, and you can sit back. Was Captain Sanders a lot bigger than you?
Yes, ma'am.
Um,
I struggled with him.
so when you made contact with him, were you trying to fight with him, or were you trying to get back away? What was going on?
My basic initial my itinerary motive was to basically stay from confrontation, from physical combat, and from being restrained to the point where I'm getting hurt or I'm doing more damage than I was intended to.
Okay, so
Off instinct.
you were trying to prevent getting hurt yourself.
Right.
Do you ever intend to hurt anyone?
No. After the slamming, I don't know if it was in the recording or not, but I pointed my finger at Officer Dosek saying, you're lucky because that's not my intentions to commence further altercation or incriminate myself.
Okay. Were you pepper sprayed instantly?
Right.
Okay. Was that before or after Captain Sanders?
That was after.
Is there anything else you want the jury to know?
No, ma'am. I conclude.
All right, I don't have any more questions. Thank you.
Does the state wish to cross-examine this witness?
Yes, Your Honor.
Your witness, Ms. Jeffcoat.
Thank you, Your Honor.
If you two will, yeah, thanks.
So when this all happened or before it happened, you were practicing, you said numerology and letterology.
Right.
And you were doing that in your dorm, correct?
Right.
Okay. And basically you're just writing down numbers and letters and those have meaning to you.
Right.
Okay. And then you made a comment that you said that you were having your moment. What does that mean?
Basically, the moment was the simple fact that prior to me being housed at Gracefield, I was already in a erratic state before entering that compound. So basically, I was already like hostile and snapping out of control before I entered that compound facility.
Okay. So before you got to Graceville, you were already acting erratic and snapping.
Right.
And were you snapping and acting erratic when Officer Dosick came to the dorm?
Right.
Okay. And when Officer Dosick, he asked you to cuff up, right?
No, he didn't. He didn't.
And I don't want you to tell me what your sentence was. I can't ask you that, but that wasn't your first day at that institution, correct?
No.
Okay. And officers have asked you to cuff up before, correct? You've had to put cuffs on inside the facility before, right?
Right.
Okay. And so for whatever reason, though, you and Officer Dosick go to talk to Captain Sanford, correct?
Right.
And this was your first time meeting Captain Sanford?
Yes, ma'am.
So he had never done anything to you in the past or anything like that?
No, ma'am.
Now you watched the same video that the jury watched, correct?
Yes, ma'am.
All right. And that's you on that video with Captain Sanford and Captain Dosick and Officer Myrick, or I'm sorry, not Captain Dosick, Captain Sanford and Officer Myrick and Officer Dosick, correct?
Yes, ma'am.
Okay.
For clarity of the record, Sanders?
Sanders, I'm so sorry.
No, it's all right. I just wanted a clear record.
But that was you and the officers on that video, correct?
Yes, ma'am.
And the jurors, you saw just like the jurors did that you tossed Officer Sanders over your shoulder, correct?
Right.
And you would agree that when you did that, he went to the ground and he didn't get back up, correct? You saw that on the video.
Right, because of the statement that the officer initially told him to stay on the ground.
So it's your testimony that he stayed on the ground, but it wasn't because of his injury. It was because Officer Dosick instructed him to stay on the ground.
Right, he told him not to get up.
Okay. Do you know of any reason why Captain Sanders would have followed Officer Dosick's? And if that was an instruction that was given, why would Captain Sanders have done that?
To my knowledge, I wouldn't understand that. Okay, so
fair enough. And you would agree, though, that Captain Sanders ended up being injured, correct? You heard the testimony from the doctor?
Right, but I have no knowledge of his death until after I got away from the facility.
Okay, so after this incident, you were transported to a different facility with the Department of Corrections, right? Okay, and then later on, you found out how bad the captain had been injured, correct?
Two institutions after that.
Okay,
I found out.
Okay, you moved a couple of different times.
Right.
All right. But you would agree, though, that Captain Sanders, the testimony is that Captain Sanders died as a result of the injury to his leg, correct?
Yes,
I don't have any other questions.
Any redirect of this witness?
No, Your Honor.
All right. Ladies and gentlemen of the jury, there is some matters that we need to consider outside of your presence, but it should not take more than just a few minutes. So if you will please retire to the jury deliberation room, we will bring you back out in just a few minutes. Yep, let's leave the notes here. James, for confirmation, our white noise machine is still on, correct? Thank you. Let the record reflect that the jurors have exited the courtroom, however, still present in the courtroom is counsel for the state, counsel for the defendant, and the defendant. We can move the defendant into his chair. Does the defense anticipate calling any additional witnesses?
No, Your Honor.
Do you anticipate resting at the next opportunity?
Yes, Your Honor.
All right, let's go through our charging conference and make sure that the jury instructions are as they should be. Will you put them up on the screen, or do you not want to do that?
Oh, no, Your Honor, I can pull them up on the screen.
All right,
I think that's the easiest. And I did email a fresh copy as well.
I have an emailed copy, so that's great. Will you put prosecutor PC on Polycom? You with me? Perfect. So instead of camera quad under Polycom, put prosecutor PC. Got it. Thank you. All right. Instruction number 1, introduction to the final instructions. Any objections? Ms. Kelly?
No, Your Honor.
As the state has prepared these instructions, the court assumes that the state is agreeable to the contents. So just jump in, Ms. Jeffcoat.
Yes.
Statement of the charge. Any objection?
No, Your Honor.
Introduction to homicide. Any objection?
Just for clarification, these haven't been amended in any way since.
The only ones that I changed since is I actually changed the font size and the boldness
For all of them.
for everything.
It
so
looks
that
like.
would all match. And then I removed that one sentence regarding the culpable negligence that we had discussed, that injury was not
Okay.
required.
Okay.
But none of this instruction has been changed.
All right, that'll save me from reading it line by line.
Understood.
Sure. So any objection to that proposed instruction?
No, Your Honor.
Ms. Kelly? How about the second page of that introduction to homicide?
No,
Now, is the last sentence there, should that be Josh Lawson may be found guilty of manslaughter, or should it be aggravated manslaughter?
Does it say manslaughter throughout? Oh, no, it says aggravated manslaughter. I think it should probably be changed to match. Well, there's 2 places where I think in that third.
Let me go to the standard. Let's see if that's a place where you're supposed to change the instruction.
The beginning of that instruction, I know it makes you select the degree and then edit it so that you only have the lesser included for the degree that was charged, because it applies basically to all homicides.
It says, for that last paragraph, it says, I now instruct you on the circumstances that must be proved before defendant may be found guilty of crime charged. And the crime charge is aggravated manslaughter, so that needs to be changed.
Does it need to be changed in that second paragraph as well, Your Honor? I think I just have the
That's all right, let me look.
second and the-
So the second paragraph in the standard says first degree murder includes the lesser crimes of second degree murder, murder, and manslaughter, all of which are unlawful. Therefore, I think the way that should read is aggravated manslaughter is unlawful. Or it should read aggravated manslaughter includes the lesser crimes. But now there's no qualifier. I mean, should that,
Your Honor, I think the introduction to homicide only applies to the homicide instructions. We don't normally put in, like, for if somebody's charged with premeditated murder, we put in secondary murder and manslaughter, but we don't put in the felony battery and aggravated batteries.
right, but what I'm saying is, do you think that this instruction only applies to first degree murder?
No, Your Honor, it applies to all homicides.
Okay, so you want it to, but it's manslaughter, not manslaughter.
Aggravated manslaughter and then, right. So this would be, I should change that to aggravated manslaughter as well.
The way the instruction reads is first
I see what you're saying. This should say aggravated manslaughter.
includes the lesser crimes of
Slaughter.
manslaughter and culpable negligence. Isn't that the two?
yes.
Well, culpable
Or just
negligence is
manslaughter, if
homicide.
that's what, the way you think that reads, all of which are unlawful.
Aggravated manslaughter includes,
Includes the lesser crime of manslaughter, all of which are unlawful, comma, all of which are unlawful. And then it goes on to read, however, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. All right, and so you have aggravated manslaughter there. And I think the other place where the crime was charged is only in the last.
that's correct. I don't see it anywhere else.
All right, fair enough. Okay, let's move on to aggravated manslaughter. Any objection to the proposed instruction there?
Thing I had said earlier was 3 reads choppy to me, and at a time, Matthew Sanders was an officer who was at the time performing duties. I think the standard had the first "at a time" taken out, but it's just a style.
At the time is not in the standard. I agree, and I saw that. So that 3 should start with Matthew Sanders was an officer who was at the time performing duties that were within the course of his employment. Who was at the time performing duties that were within the course of his employment. We need to take away a space between officer and who. But yes, anything else, Miss Kelly?
Not that I can tell from here.
All right. How about when there are lesser included crimes or attempts? We previously discussed that these were all the lessers that the defense wanted, and the defense continues to want those lessers. Is that right?
Yes, Your Honor.
Is there any reason the order in which they were prepared?
So, Your Honor, I attempted to put them in the order of most serious to least serious.
And culpable negligence is above or is more serious than felony battery?
No, it's.
No, I'm sorry, it should be,
It's
it's
twice.
in there twice. It should only be in there once.
Listed twice. Came out twisted.
All right. Any objections as written now with deleting culpable negligence, the first proposed instance of culpable negligence?
No,
Ms.
Your
Kelly? All right, fair enough. So then we move on to the first lesser included of manslaughter. Is there any objection to that proposed jury instruction?
No, Your Honor.
What about aggravated battery on a law enforcement officer?
On my copy, there's 2 spaces between his and will in number 1, but I don't think it matters since it's going to the next line.
Agreed. We just need to take away the space between his and will on number 1. Anything else, Ms. Kelly?
No, Your Honor.
Let's go back to when there are lesser included offenses. The lesser needs to read aggravated battery on a law enforcement officer. On a law enforcement officer. All right, so let's move down to felony battery. Any objection, Ms. Kelly, to that proposed instruction? Now let's move on to battery on a law enforcement officer is the next lesser included. Any objections to the proposed instruction there? Then finally, battery and then culpable negligence. Battery, any objection?
No, Your Honor.
Culpable negligence, any objection?
No, Your Honor.
Moving on to plea of not guilty, reasonable doubt, and burden of proof. Any objection to the proposed instructions there?
When we were initially, yes, please. When I had initially reviewed these in paragraph, I guess it's 5, it's the first full paragraph right there. That first sentence, it was, when I checked my paper books and Lexis, it was not there, but Ms. Jeffco did check, and it was amended to the standard jury instruction, I think effective last week, or I'm sorry, last week of May. So we did, just for clarification of the record, we did address that, and we did look at it, so I believe that is correct. Did that sentence proof beyond a reasonable doubt does not mean proof beyond all doubt?
Let me pull up the standard. Where did you think it was originally?
It was that first sentence, I'm just gonna highlight it. That first sentence there is an amendment and an addition. It was not in the old instruction.
Fair enough. The court is looking at today's version of the criminal jury instructions online, and I agree that that's what's there. Fair enough. Anything else on that instruction?
No,
Ms.
Your
Kelly? Weighing the evidence, any concerns there? And let's talk about 6 through 10.
First 5, I'll remove the italics there. I don't think 6.
I don't think 6 applies either. Does Ms. Kelly think that it does? And if so, give me your argument.
No, I don't believe so.
How about 7?
No,
How about 8?
no.
How about 9 does apply, obviously. And so let's make sure we only keep convicted of a felony and take out all the rest. And then was originally 10, but is now 7, should all come out as well. Any objections?
No
No.
objection.
Okay, so let's take out some of the rest of the italics. We need a law enforcement witness testimony. We need the expert witness testimony portion and the part about the defendant testifying. We don't need the witness talking to a lawyer, I don't think, unless you want it there.
I don't see a need for it.
Do you want it? I mean, you talked to some of the witnesses and you talked about that. You want it there? All right, so let's take out the italics of witness talk to the lawyer and given all cases, let's take that out as well. All right, fair enough. Now let's move on to defendant not testifying. Let's take all of that out. Will you scroll up so I can see what it looks like up there? Yeah, scroll up one more. Okay, fair enough. Now you can scroll back down. So there's no instruction regarding the defendant not testifying. Now the rules for deliberation. Any concerns there, Ms. Kelly?
Good.
All right. Moving on to cautionary instruction. Any objections there?
No objections.
All right, then the verdict instruction.
No.
All right, then finally, let's go to submitting the case to the jury. Can you take away the spaces between the title and there we go. I don't think we need a plural verdict forms because there's just one. There's another one right above in the sentence or the line, excuse me, right above. All right.
The only request I make on this one is in the paragraph 3, many of you have cell phones, tablets, laptops. I always like to specifically include smartwatches because I know it's been an issue.
I normally just tell them that even though it's not in the standard. So I'm happy to, many of you have cell phones, tablets, laptops, smartwatches. Let's just add it. Are you, any objection, Ms. Jeffcoat?
No, the state has no objection.
Smartwatches or other electronic devices. I think there's an extra space. All right, keep scrolling down. As exhibits, there's a space there. All right, any final objections to submitting the case to the jury?
No, Your Honor.
All right, let's talk about the verdict form, guys.
And I put a fresh verdict form, I think.
I have one. All right, so let's look at the proposed verdict form. 1, aggravated manslaughter. 2, manslaughter. 3, aggravated battery of an officer. 4, felony battery. 5, battery on a law enforcement officer. 6, battery. 7, culpable negligence. 8, not guilty. Any reason we don't put of an officer on ag manslaughter and manslaughter, or is that just the way the proposed go?
From what I could see,
Can put it on there.
I'm okay with either one. I just wanted to bring that up in case either of you wanted it.
I think for the aggravated battery, we changed it from on an officer to, or of an officer to on a law enforcement officer in the jury instruction. So I'm happy to change it to match.
Let me see. It says aggravated battery on a law enforcement officer.
Right, in the instruction, in the paper instruction I gave you, but I think you requested that I change it when we were just going through them. I can pull it back up.
Yeah. I think I was just going with whatever was on the attempt.
Right.
No, I think we kept it on a law enforcement officer and we added that to the attempt. Aggravated battery on a law enforcement officer. You want to put that in the verdict form? I think that's consistent. Any objection, Ms. Kelly?
I'm sorry.
So the way it reads in the instructions is aggravated battery on a law
And
enforcement
so it's
officer.
supposed to of an officer. That's fine.
Correct. And in the instruction, it says aggravated manslaughter, it says manslaughter, it says aggravated battery on a law enforcement officer, felony battery. All right, so that's consistent. Let's delete a space between 7 and 8 and where the lesser included attempts are. It was originally written aggravated manslaughter of an officer. So I think we should just make it consistent. So if we're talking aggravated manslaughter in the verdict form and in the instruction, then on what lesser included attempts, I think we should just put aggravated manslaughter. What do you think? No, so I would take of an officer off because in your instruction, it says aggravated manslaughter. It does not say of an officer.
Okay.
But it can if,
I'm fine with it how it is. Is it okay?
so then go, it's right there, but you need to go to the lesser included and change it in the lesser included
On which one, Your Honor?
under the lesser included instructions when there are lesser included crimes. In the instruction,
Oh,
the instruction about lesser included.
Well,
I'm sorry.
right under introduction to homicide, in the very first sentence is Joshua Lawson is accused of aggravated manslaughter of an officer. So that says it there, but in the jury instruction is just aggravated manslaughter. So
I just think we need to be consistent. What do you guys want?
I mean, he's charged with aggravated manslaughter of an officer. So
All right, so then go back to the beginning. And where it says aggravated manslaughter of an officer. So then go to your verdict form and put aggravated manslaughter of an officer. All right, and then scroll down. Let's see how the spacing looks. I would move up, so say we all, there we go. Any objections as it read now, Ms. Kelly?
Change 3 to have a law enforcement officer. No.
All right. Shayla, whoever is going to print these instructions, I can't wing it. And so if they can make sure to have it here before the closings are done, and then Chuck, if you'll get it from whoever and bring it up to me, that would be great.
It's in my box. If you'll print 4 copies of
All right. Anything else that we need to consider before we bring the jurors in? Are there any further motions that any parties wish for me to consider?
Your Honor, I would just renew my motion for judgment of acquittal. Once again, the evidence is that this was a brief encounter under the jury instructions for aggravated manslaughter. It states that a violation of a duty to act reasonably without any conscious intention to do harm is negligence, and the defendant cannot be guilty of aggravated manslaughter by causing death because of a merely negligent act. Culpable negligence requires the course of conduct showing a reckless disregard of human life or the safety of others. So I just would argue that this one split second muscle memory reaction does not arise to the level of culpable negligence.
Okay, the court's ruling on the JOA, even after considering the defendant's testimony, will remain as previously announced. Any other reasons or anything else before we bring the jurors in?
Nothing from the state.
Anything from the defense?
No, Your Honor.
All right, let's all remain seated. We'll bring the jurors in and we'll start closing arguments. Give me 1 second, James, to get to that instruction. You can-
Yes, Your Honor, at this time, can all witnesses be released?
Any objection?
No objection.
So ordered. Let's wait for them to come in. That way our closings, guys, do your best to talk into a microphone so that everyone can hear you. And Chuck, will you point that microphone towards the speakers so that, and the one by the jurors?
Do I need to re-announce that we're resting when the jury is?
I'm going to ask you to. Are any witnesses coming in? Okay, let me wait on Rory, or maybe not, because he's bringing the instructions, right? Okay, I think they're coming. Great. All right, let's bring the jurors in. Everybody remain seated, please.
Jury in the courtroom.
Welcome back, ladies and gentlemen. Please have a seat. Ms. Kelly, does the defense wish to call any additional witnesses?
Your Honor, at this time the defense rests.
All right. Ladies and gentlemen of the jury, both the state and the defendant have now rested their case. The attorneys will now present their final arguments. Please remember that what the attorneys say is not evidence or your instruction on the law. However, do listen closely to their arguments. They are intended to aid you in understanding this case. Each side will have equal time, but the state is entitled to divide this time between an opening argument and a rebuttal argument after the defense has given its closing argument. Any objection to the reading of standard instruction 2.7?
No, Your Honor.
Is the state ready to proceed? You may proceed.
Members of the jury, at this time, you have seen and heard all of the evidence and testimony you're going to receive in this case. And the state and the defense will put forth our arguments as things that we think you should look at, things that you should consider in making your decision. The evidence before you is without doubt that but for the actions of the defendant, Joshua Lawson, Captain Sanders would not have had his femur broken, would not have had a blood clot, and would not have died on March the 18th as a result of a pulmonary embolism that resulted or originated from the femur that was broken during the incident with Joshua Lawson. Members of the jury, the judge is going to read you the instructions on the law that you're to follow. I want to go over some of those with you at this time. I won't go over all of them. Something to keep in mind is that while the instructions are long, they're very important. And the judge is actually going to give you a paper copy of the instructions that she reads to you. So you don't have to worry about writing it down while she's talking. You'll have a paper copy to take in the back while you deliberate. If for any reason, what I say or the defense attorney says is different regarding the law to what the judge reads, it's the law that the judge reads you that you're to follow. We always try to be as accurate as we can, but just in case, you always should follow the law as the judge reads it. So, the defendant, as you know, is charged with aggravated manslaughter, and it's aggravated manslaughter of a law enforcement officer. There are several lesser included offenses that you will be asked to consider by the court. Those
Ms.
include.
Jessica, let me stop you. I believe our TV stopped. Were you trying to broadcast something? Is it broadcasting here, Chuck?
No, I think we need to put prosecutor PC.
Prosecutor PC to the TVs. I apologize for the interruption.
Oh, no, I'm sorry. I should have noticed that that's.
Are you still plugged in?
I am.
It's showing on the.
There we go. It was showing on that one, but not, okay. All right.
So
There we go.
let me just back up. All right. So, as you know, the defendant is charged with 1 count of aggravated manslaughter of a law enforcement officer. There are lesser included offenses that you see on the list before you, and the court will ask you to consider each and every one of those. Lesser included offenses are essentially crimes that are completed on the way to committing the primary offense with which the defendant is charged. So the ones that you will be asked to consider today are manslaughter, aggravated battery on a law enforcement officer, felony battery, battery on a law enforcement officer, simple battery or just battery, and culpable negligence. And I want to go through each of those with you just so you can see some of the difference. And it's usually easiest to start with the least serious offense and then kind of work your way up, because you'll see how they kind of build upon each element. So every crime has certain elements the state has to prove, and the standard of proof is beyond and to the exclusion of every reasonable doubt. So culpable negligence has 2 elements. The first element is that Joshua Lawson inflicted actual personal injury on Matthew Sanders, okay? And the second element is that he did through culpable negligence. And we're going to go through we're going to talk about culpable negligence some more, but it's more than just an accidental injury, okay? It has to be through some gross and flagrant behavior, some actions that would indicate that he had a disregard for the safety of Mr. Sanders. And I'm going to talk about this next, the next 2 kind of together, because the elements are essentially the same. They have the same first element and then they build. So to prove the crime of battery, the state would have to prove that Joshua Lawson actually and intentionally touched or struck Matthew Sanders against his will. And to complete a battery, and we sometimes call this a simple battery, it's any touching or striking that is against the will of the victim, any unwanted touching. So literally poking somebody, pinching somebody, shoving them in the shoulder, those are all ways that battery can be completed. Even spitting on a person is considered a battery in the state of Florida. So certainly we have evidence that there was a touching. And then the second, if you were to the first element is the crime of battery. To prove the crime of battery on a law enforcement officer, there's a second element. The first element is just the same as the one we just read. And then the second element is that Matthew Sanders was a law enforcement officer. Now, in the instructions that the judge will read you, there will be definitions, and it will explain that a corrections officer is a law enforcement officer for these purposes. And then the third element to prove battery on a law enforcement officer is that Joshua Lawson knew Matthew Sanders was a law enforcement officer. We heard repeated testimony about him being referred to as Captain Sanders. We know that he was told that he was going to speak with Captain Sanders. We could see the video where the officer was wearing his uniform. And so the defendant would certainly have known of Matthew Sanders' status as a corrections officer. Okay. Now, let's go on to felony battery. So felony battery, you're going to, I'm sure, recognize that first element because it is the same as it was for the crimes of battery and battery on a law enforcement officer. And that is that Joshua Lawson actually and intentionally touched or struck Matthew Sanders against his will. So again, this touching or striking, it's not an accident. It's not I tripped and I accidentally pushed you or hit you. It is purposefully making contact with another person. And then that the second element of that is that Joshua Lawson caused Matthew Sanders great bodily harm, permanent disability, or permanent disfigurement. All right. So the next thing we're going to talk about then is felony battery. Felony battery is similar, aggravated battery, I apologize. Aggravated battery is similar to felony battery. Okay, and again, you'll recognize that first element that the defendant intentionally touched or struck the victim. But the next element, again, is a little bit different than in felony battery, because the difference between aggravated battery and felony battery is not just that when the person was touched or struck, and that they received great bodily harm, it's that the defendant intentionally caused and knowingly caused great bodily harm. Okay. And then this is aggravated battery of a law enforcement officer. So the third element would that be that Matthew Sanders was an officer. And again, there'll be a definition that will include Matthew Sanders' status as an officer and that he was a corrections officer. So I want to talk to you a little bit though about that second element, about intent. Okay. Intention, somebody's intentions are an operation of the mind. There's a couple of different ways though that you as jurors can determine how what a person's intentions are. And by operation of the mind, I mean, it's something that's going on in a person's head. So there's a couple of different ways. One, a person can tell you that, well, you know, when I struck the match, I meant to set the firework on fire. Okay. So that's one way to determine a person's intent. And then once they've told you that, you can either as jurors decide whether or not you believe what the person says. Okay. They could be telling the truth. They could be lying. Another way though, to determine what a person's intentions are by watching their actions. And so remember when we talked about the fireworks display and jury selection, if you see me strike my match and then put it down to the fuse on my bottle rocket, you can determine without me ever telling you that I intended to light that match. Okay. So how does that apply to the case at hand? Well, we saw the video, we've heard testimony, we've now heard the testimony of the defendant, okay? And he says that he did not intend to harm the officer. He acknowledges that he did toss the officer. He acknowledges that the officer died, you know, as a result of the injuries he received, but he says that he did not intend to cause those injuries. Well, what would one think would happen when you throw a person onto a concrete ground, okay, a concrete floor? So that is it foreseeable that a person would be seriously injured as a result of being thrown to a concrete floor? And this wasn't just a simple pushing. He went over the defendant's shoulder onto the ground. And so it was a very hard fall. And we know from the testimony that it was hard enough to fracture Captain Sanders' femur bone, which ultimately led to his death. So from the circumstances of this incident, you as jurors can make a determination that the defendant intentionally and knowingly caused great bodily harm to Matthew Sanders, because his actions, it wasn't just a push in the chest, get away from me. He flung him to the ground, and the resulting injury is certainly foreseeable. And then, of course, the fourth element, again, similar to the battery on a law enforcement officer, is that Joshua Lawson knew that Matthew Sanders was a law enforcement officer. And we talked about that already, about what he would have known on that compound at that time. And then there's a fifth element, is that Officer Sanders, or Matthew Sanders, was engaged in the lawful performance of his duties when the battery was committed against him. And so we know from the testimony that he went to work that day, that he had worked for the Department of Corrections at that institution for many years, and that he was a captain at that facility, and that Officer Dosick, in dealing with the defendant, had taken him to see the captain as part of their kind of escalation of dealing with an inmate who was having some issues that day. And we'll talk more about that shortly. So the next lesser included offense, and this will be the last lesser included offense before we talk about the primary charge, is the crime of manslaughter. So to prove the crime of manslaughter, the state must prove that Matthew Sanders is dead. And certainly we heard testimony from the medical examiner as well as from Captain Sanders' widow, Mrs. Sanders, about his death, and that he died on March the 18th of 2021. There's two different ways that the state can prove element 2. So this is something to pay maybe extra attention to. So the first way that element 2 can be proven is that Joshua Lawson intentionally committed an act or acts that caused the death of Matthew Sanders. Okay. So again, here's that word intent. Now, the state does not have to prove that he intended to cause the death of Captain Sanders. If we were trying to prove that he intended to kill Captain Sanders, he would be charged with first-degree premeditated murder. That's not what he is accused of. But he is accused of intentionally throwing Captain Sanders, you know, kind of hurling him over his shoulders or slinging him to the ground. So that is the intentional act which ended up ultimately causing the death of Matthew Sanders. The second way, and then because there's an or the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. So we have manslaughter by act, meaning that Joshua Lawson committed intentional act. And then we also have manslaughter by culpable negligence, meaning that the defendant committed a negligent act which resulted in the death of Captain Sanders. And we'll talk about culpable negligence in more detail in just a moment. We already went through this one. Let's see here. All right. So this is the primary offense with which the defendant is charged, and that is aggravated manslaughter. And so again, the state has to prove that Matthew Sanders is dead. And then the second thing we have to prove is that the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. And then 3, that at the time that Matthew Sanders was an officer, Matthew Sanders was an officer at the time that this occurred, and he was performing his legal duties. Okay, so those are the 3 things that the state has to prove: is that that the victim is dead, that the death was caused by the defendant's culpable negligence, and that at the time of the incident that led to the death, that the officer was in fact an officer and performing his legal duties. So let's talk more about culpable negligence, because I know that that has come up in a couple of our instructions. And so culpable negligence, the instruction that I anticipate the judge will read to you says that every person has a duty to act reasonably towards others. If there's a violation of the duty without any conscious intent to harm, that violation is negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to the consequences, or to which shows a wantonness and recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. Okay, so let's talk about that some more, and then we'll talk about that last one. So the defendant's actions, and I'm talking specifically about not just his actions towards the officer that day, but his general mood. You know, the first officer that testified, he got called out there initially because the defendant was refusing to have cuffs placed on him. And by the defendant's own admission, he was having a moment. He was acting erratic, I believe were what his words were. And this is according to the defendant. He was having a moment, snapping off and erratic, and that was even before he got into the institution. And then he said while he was working on his numerology and his letterology, that he was snapping off at that time. And so there's an issue that requires Officer Dosick to come out there. But at the time, he is somewhat amenable. He knows what's going on because he agrees to go with the officer to meet with the captain, and he doesn't have to be hauled down there or dragged down there. But apparently when he is meeting with the captain, he is still having some issues because the request is simple at this point from the captain. It is to cuff up, which is a standard practice at a DOC facility. And this wasn't his first day there. He had been cuffed before. And so when they try to cuff him, he ends up, picking the officer completely off of the ground. And the officer is bigger than the defendant. There's no question about that. But he ends up picking him up and bringing him down with enough force to cause major and serious injury. Okay. And so that behavior of throwing another human being onto a concrete floor in that way was grossly careless. It certainly did not have any regard for the safety of Captain Sanders. And while there's no evidence that he intended to kill Captain Sanders, that was ultimately the result. And so the third part of culpable negligence is that the negligent act or omission must have been committed with an utter disregard to the safety of others, which again, he was not concerned about the safety of the officer. And it says that culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. And again, in this situation, the defendant should have known or reasonably should have known was likely to cause this great bodily injury to Captain Sanders. And that is exactly what happened. Members of the jury, there is no other evidence that Captain Sanders died from anything but the actions of the defendant, Joshua Lawson. And so I know that the doctor was questioned about, Captain Sanders' prior medical conditions and all of these different things that could cause a pulmonary embolism, and some of which there's no testimony that he even had some of those issues. But the uncontroverted testimony is that the clot which ultimately killed Captain Sanders originated from the broken femur, which occurred on March the 18th when Joshua Lawson threw him onto the concrete sidewalk there in the DOC facility. So with that, members of the jury, I will ask you to find the defendant guilty of the offense of aggravated manslaughter. Thank you.
Is the defense ready to proceed?
Yes, Your Honor.
Ms. Kelly, you may proceed.
Thank you, Your Honor. Can y'all pull up my computer?
We can.
Okay. Is that mine or is that, because that's what it's like.
Give us one. That's you.
Okay.
I think, right?
Yes.
Okay.
It's just on screen and a half. Hey, good afternoon, ladies and gentlemen. I'm going to cover a lot of the same ground as Ms. Jeffcoat because honestly, the charges and the elements of the offenses are really why we're here today. I mean, the evidence is the evidence. You've seen the video for yourself. So the elements of the offenses is the big question here. I'm going to start out, and all these slides are going to be included in the jury instructions that go back with you. Starting out with, judge is going to instruct you on reasonable doubt and burden of proof. An accused person is assumed not guilty or innocent unless that presumption has been overcome by the evidence. So the evidence is what we hear today. The state has the burden of proving the crime was committed, that a particular crime was committed and the defendant was the one who committed the crime. We're not questioning who all was involved in this incident. We're only here about what the actual crime was. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflicts in the evidence, or a lack of evidence. And the defendant is not required to present evidence or prove anything. So those are just kind of some basic things to keep in mind. One of the other instructions, I'll get to that in a minute. So Ms. Jeffcoat kind of went over the elements. This is her battery. She addressed that. Battery of a law enforcement officer. We went through all of those elements. Felony battery. Aggravated battery. What's important here, and Ms. Jeffcoat addressed this, is the big difference between aggravated battery and felony battery is the intent. So felony battery says, okay, you did an act, you intended to do the act, and that act resulted in great bodily harm, permanent disability, or permanent disfigurement. So that's felony battery. But aggravated battery requires that you intend to do that great bodily harm, that you intend the effects of that. So it's not something where you can, it has to be foreseeable. It has to be something that you can foresee coming, that you intend to happen. And so I'd argue that in this instance, Mr. Lawson never intended any injury to Captain Sanders, that it was a quick spur of the moment, evasive maneuver. Mr. Lawson is 5'5", 120 pounds. Captain Sanders was 6'2", 220 pounds. There's almost a foot difference and 100 pounds difference between the two of them. And Ms. Jeffcoat addressed this earlier, but kind of some things that I have highlighted here that I think are of particular importance. So if there is a violation of this duty of reasonable care, if there is no conscious intention to do harm, that violation is just simple negligence. It's not culpable negligence, it's just negligence. Culpable negligence requires a course of conduct showing a reckless disregard for human life. This is something like if you don't feed your baby for 2 weeks and the baby dies, or if your grandmother you don't take care of your grandmother and she succumbs to an injury. This requires a course of conduct. This isn't just a spur of the moment split incident. Excusable homicide, this is one of the instructions that the judge is going to read to you. What is of note here is when passing all of this legislation, when our lawmakers were looking at things that happen, things that they look at right here under subsection 2 is when a killing occurs by accident and misfortune in the heat of passion or upon any sudden insufficient provocation. So you don't intend for anything bad to happen. It's a sudden kerfuffle. And then 3, when the killing is committed by accident and misfortune resulting from a sudden combat, when there's no dangerous weapon present and it is not done in a cruel and unusual manner. The point of this is the legislature realizes that there are times when fight or flight takes over, when there are times when we don't have time to reflect. And so they want to address that by saying there are certain circumstances where what would otherwise be a homicide are not homicides. Ms. Jeffcoat addressed the elements of aggravated manslaughter But once again, I'm going to highlight the notes that come with those further instructions. The defendant cannot be guilty of aggravated manslaughter if it was the result of a merely negligent act. And once again, without any conscious intention to harm, that violation is simple negligence. It requires a course of conduct. So it's more than just one thing. It's an ongoing course of acts. Here we've got manslaughter. One of the instructions you're going to have here is every person has a duty to act. And if there's no violation without any conscious intent to harm, that's negligence, and the defendant cannot be guilty. We had an expert witness, that was Dr. Radke. This is the instruction on expert witnesses. An expert is only reliable as to what you believe them to be an expert about. And then this is the image that sticks with me. This is a few seconds before the immediate contact with Captain Sanders and Mr. Lawson. As you can see here, Mr. Lawson is trying to disengage. He's trying to walk away. And I'm not sure, but to me, and you're gonna have to use your own judgment, but it appears right here that as always pepper spray. And Mr. Lawson told you from the witness stand, he was simply trying to de-escalate the situation and get some space. One of the other issues here is going to be causation. Mr. Lawson indicated to you that he was engaged in this physical conflict with Captain Sanders. But some of the things that we need to look at in reaching a verdict are the factors involved in Captain Sanders' death. His wife told us that on the morning of his death, unfortunately, they had been to the doctor's office. He had complained of some symptoms, and the doctor's office ignored it. The doctor's office said, "You're fine, go home," after he had complained of coughing up blood. His wife had indicated to us that he suffered from diabetes, which has circulatory issues related to it, that he had a history of cancer treatments, that he would walk around at work and he would cut grass, but he wasn't a routine exerciser, that he was on high blood pressure medication. These are all things that contribute to blood clots. These are all things that should have been addressed by his doctor. If there was any culpable negligence, in my mind, it was on behalf of his physicians who sent him home after he reported coughing up blood. They didn't give him any compression stockings. They didn't provide him with any blood thinners. There was an absolute failure by the medical profession on behalf of Captain Sanders. Dr. Radke told us that the blood clots occur in about 1% of these cases. So I submit to you that Captain Sanders' death was not foreseeable as a result of the actions of Mr. Lawson, and that the negligence that occurred was on behalf of the doctors who failed Captain Sanders. So with that in mind, I would ask that you come back on a lesser offense. It is not the belief of myself or Mr. Lawson that he was the cause of Captain Sanders' death. He certainly bore no ill will to Captain Sanders. They had never met. They had no prior disagreements. Thank you for your time.
Is the state ready for its rebuttal?
Yes, Your Honor.
You may proceed.
Members of the jury, we are at the close of the trial, and Ms. Kelly is right. A person who stands accused of a crime is innocent until proven guilty. They are presumed to be innocent. But he has been overcome by the evidence, and he is no longer presumed to be innocent at this time, because the evidence indicates that but for the actions of Joshua Lawson, Captain Sanders would not have received an injury that day. Now, the defense has talked a lot about things that could have been like cancer or his workout routine, or what the doctors did or didn't do. Okay, but those are all speculation. And recall the jury instruction that we talked about during voir dire, beyond a reasonable doubt, and the judge will read that to you. And again, proof beyond a reasonable doubt is not proof beyond all doubt. That's the beginning of that paragraph of the instruction. But then it goes on to say that a reasonable doubt is not a mere possible speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. And members of the jury, in this situation, there is no other evidence as to what caused the injury and ultimately the death of Captain Sanders other than the defendant's actions. Now, the defendant did testify that he did not intend to harm the officer, but he did admit that that was him on the video tossing the officer to the ground. You also have to weigh his credibility. And one of the things that the court will tell you about credibility, there's a list of factors that you can consider. One of those is, has the person been convicted of a felony? Well, the only person to testify before you all today that has been convicted of any felony is the defendant, Joshua Lawson. He has 4 felony convictions. Also, whether or not the evidence seems to fit with other evidence in the case. And the defendant made some other kind of odd statements about things that did not appear to happen on the video, like the officer's glasses came off his face when he was adjusting his belt, I think is what he said. And so those are things that do not line up with the other testimony evidence in this case. This is a unique situation because the circumstances leading up to this aggravated manslaughter and the injury itself are all caught on video. And so you can see exactly what the officer or Captain Sanders and the other officers are doing and what the defendant is doing. Did he back up? Yes, absolutely he did. But this is not the same as a situation of 2 people walking up to each other on the street. The defendant is an inmate at a correctional institute. He is being held there as punishment for crimes that he has previously convicted. And so if he wanted to de-escalate the situation, all he had to do was submit to hand restraints. That is all that the officers had asked him to do throughout, and he continued to refuse to submit to hand restraint. So when the officer went to physically put the hand restraint on him, which he is, required to do as part of his job, is when the inmate, picked him up and threw him to the ground. Okay. Recall, if you will, the testimony of Officer Myrick and Officer McCrary. They specifically use the word body slammed, that Captain Sanders was body slammed by the defendant. And the resulting injuries to Captain Sanders are completely and totally foreseeable to body slamming an individual onto a concrete sidewalk. Members of the jury, we talked in jury selection about negligent acts, about foreseeable acts, and his act of body slamming the officer onto a concrete sidewalk, it is the shooting of the firework in the gas station. The resulting injury, the resulting hip fracture, or femur fracture, is a foreseeable consequence of that type of action. And so, members of the jury, the defendant has committed battery by touching or striking the officer. He's committed felony battery by causing serious injury. He's committed aggravated battery by doing an act that he knew or should have known would cause that type of injury. He has committed manslaughter, both by committing an intentional act of throwing the officer, which ultimately killed him, as well as through culpable negligence by acting in a way that disregarded the safety of Captain Sanders. And he has done all of this against the law, against and in violation of the laws of the state of Florida. So, members of the jury, there is no question that the defendant's actions resulted in the death of Matthew Sanders, and he should be held accountable for his actions. He is an adult, and all adults must abide by the laws of the state of Florida. And in this case, Your Honor, members of the jury, we would ask that you find the defendant guilty. Thank you.
Amanda. Members of the jury, I thank you for your attention during this trial. Please pay attention to the instructions that I am about to give to you. Joshua Lawson, the defendant in this case, has been accused of the crime of aggravated manslaughter of an officer. Joshua Lawson is accused of aggravated manslaughter of an officer. Aggravated manslaughter of an officer includes the lesser crime of manslaughter, all of which are unlawful. However, a killing that was excusable or that was committed by the justifiable use of deadly force is lawful. If you find Matthew Sanders was killed by Joshua Lawson, you will then consider the circumstances surrounding the killing in deciding if the killing was aggravated manslaughter or whether the killing was excusable or resulted in justifiable use of deadly force. The killing of a human being is justifiable homicide and lawful if necessarily done while resisting an attempt to murder or commit a felony upon the defendant, or to commit a felony in any dwelling house in which the defendant was at the time of the killing. The killing of a human being is excusable and therefore lawful under any of the following three circumstances. 1, when the killing is committed by accident and misfortune, in which any lawful act by lawful means with usual ordinary caution and without any unlawful intent. Or 2, when the killing occurs by accident and misfortune in the heat of passion upon any sudden and sufficient provocation. Or 3, when the killing is committed by accident and misfortune resulting from a sudden combat if a dangerous weapon is not used and the killing is not done in a cruel or unusual manner. A dangerous weapon is any object that will likely cause death or great bodily harm if used in the ordinary and usual manner contemplated by its design or construction. Great bodily harm means great, as distinguished from trivial, slight, minor, or moderate harm, and as such does not include mere bruises. I now instruct you on the circumstances that must be proved before Joshua Lawson may be found guilty of aggravated manslaughter of an officer or any lesser included crime. To prove the crime of aggravated manslaughter of an officer, the state must prove the following three elements beyond a reasonable doubt. 1, Matthew Sanders is dead. 2, the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. 3, Matthew Sanders was an officer who was at the time performing duties that were within the course of his employment. Do you guys need to approach? I'm happy for you to. Come on up. I don't need a court reporter. I'm going to restart the instruction on aggravated manslaughter to make sure that I have not misread any portion of it. To prove the crime of aggravated manslaughter of an officer, the state must prove the following three elements beyond a reasonable doubt. 1, Matthew Sanders is dead. 2, the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. 3, Matthew Sanders was an officer who was at the time performing duties that were within the course of his employment. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. The defendant cannot be guilty of aggravated manslaughter by causing a death because of a merely negligent act. But culpable negligence is more than a failure to use ordinary care towards others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life, or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of a conscious indifference to consequences, or which shows wantonness or recklessness, or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. The negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. A defendant cannot be guilty of aggravated manslaughter if the killing was either justifiable or excusable homicide, as I have previously instructed you. Officer means any person employed or appointed as a full-time, part-time, or auxiliary law enforcement officer, correctional officer, or correctional probation officer. In considering the evidence, you should consider the possibility that although the evidence may not convince you that the defendant committed the main crime of which he is accused, there may be evidence that he committed other acts that would constitute a lesser included crime. Therefore, if you decide that the main accusation has not been proved beyond a reasonable doubt, you will next need to decide if the defendant is guilty of any lesser included crime. The lesser crimes indicated in the definition of aggravated manslaughter of an officer are manslaughter, aggravated battery on a law enforcement officer, felony battery, battery on a law enforcement officer, battery, and culpable negligence. To prove the crime of manslaughter, the state must prove the following two elements beyond a reasonable doubt. 1, Matthew Sanders is dead. 2, Joshua Lawson intentionally committed an act or acts that caused the death of Matthew Sanders, or the death of Matthew Sanders was caused by the culpable negligence of Joshua Lawson. Every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, the violation is negligence. The defendant cannot be guilty of manslaughter by committing a merely negligent act, or if the killing was either justifiable or excusable homicide, as I have previously instructed you. In order to convict of manslaughter by act, it is not necessary for the state to prove that the defendant had an intent to cause death, only an intent to commit an act that was not merely negligent, justified, or excusable, and which caused death. I will now define culpable negligence for you. As I have said, every person has a duty to act reasonably towards others. If there is a violation of that duty without any conscious intention to harm, that violation is negligence. But culpable negligence is more than a failure to use ordinary care toward others. In order for negligence to be culpable, it must be gross and flagrant. Culpable negligence is a course of conduct showing reckless disregard of human life or of the safety of persons exposed to its dangerous effects, or such an entire want of care as to raise a presumption of conscious indifference to consequences, or which shows wantonness or recklessness or a grossly careless disregard for the safety and welfare of the public, or such an indifference to the rights of others as is equivalent to an intentional violation of such rights. A negligent act or omission must have been committed with an utter disregard for the safety of others. Culpable negligence is consciously doing an act or following a course of conduct that the defendant must have known or reasonably should have known was likely to cause death or great bodily injury. To prove the crime of aggravated battery on a law enforcement officer, the state must prove the following 5 elements beyond a reasonable doubt. The first element defines the crime of battery. 1. Joshua Lawson actually and intentionally touched or struck Matthew Sanders against his will. 2. Joshua Lawson, in committing the battery, intentionally or knowingly caused great bodily harm to Matthew Sanders. 3. Matthew Sanders was an officer. 4. Joshua Lawson knew Matthew Sanders was a law enforcement officer. 5. Matthew Sanders was engaged in the lawful performance of his duties when the battery was committed against him. The court now instructs you that a correctional officer is a law enforcement officer. Great bodily harm has already been defined. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. To prove the crime of felony battery, the state must prove the following 2 elements beyond a reasonable doubt. 1. Joshua Lawson actually and intentionally touched or struck Matthew Sanders against his will. And 2. Joshua Lawson caused Matthew Sanders great bodily harm, permanent disability, or permanent disfigurement. Great bodily harm has already been defined for you. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. To prove the crime of battery on a law enforcement officer, the state must prove the following 4 elements beyond a reasonable doubt. The first element defines the crime of battery. 1. Joshua Lawson actually and intentionally touched or struck Matthew Sanders against his will. 2. Matthew Sanders was a law enforcement officer. 3. Joshua Lawson knew Matthew Sanders was a law enforcement officer. 4. Matthew Sanders was engaged in the lawful performance of his duties when the battery was committed. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. To prove the crime of battery, the state must prove the following element beyond a reasonable doubt. Joshua Lawson intentionally and actually touched or struck Matthew Sanders against his will. An intentional touching or striking includes situations where a defendant knows that a touch or strike is substantially certain to result from his or her act. To prove the crime of culpable negligence, the state must prove the following 2 elements beyond a reasonable doubt. 1. Joshua Lawson inflicted actual personal injury on Matthew Sanders. 2. He did so through culpable negligence. The term culpable negligence has already been defined for you. The defendant has entered a plea of not guilty. This means that you must presume the defendant is innocent. That presumption stays with the defendant as to each material allegation in the information through each stage of the trial, unless it has been overcome by the evidence to the exclusion of and beyond a reasonable doubt. To overcome the defendant's presumption of innocence, the state has the burden of proving the crime with which the defendant is charged was committed, and the defendant is the person who committed the crime. The defendant is not required to present evidence or prove anything. Whenever the words reasonable doubt are used, you must consider the following. Proof beyond a reasonable doubt does not mean proof beyond all doubt. A reasonable doubt is not a mere possible doubt, a speculative, imaginary, or forced doubt. Such a doubt must not influence you to return a verdict of not guilty if you have an abiding conviction of guilt. On the other hand, if, after carefully considering, comparing, and weighing all of the evidence, there is not an abiding conviction of guilt, or if having a conviction, it is one which is not stable, but one which wavers and vacillates, then the charge is not proved beyond every reasonable doubt, and you must find the defendant not guilty because the doubt is reasonable. It is to the evidence introduced in this trial and to it alone that you are to look for that proof. A reasonable doubt as to the guilt of the defendant may arise from the evidence, conflict in the evidence, or lack of evidence. If you have a reasonable doubt, you should find the defendant not guilty. If you have no reasonable doubt, you should find the defendant guilty. It is up to you to decide what evidence is reliable. You should use your common sense in deciding which is the best evidence and which evidence should not be relied upon in considering your verdict. You may find some of the evidence not reliable or less reliable than other evidence. You should consider how the witnesses acted as well as what they said. Some things that you should consider are: 1, did the witness seem to have an opportunity to see and know the things about which the witness testified? 2, did the witness seem to have an accurate memory? 3, was the witness honest and straightforward in answering the attorney's questions? 4, did the witness have some interest in how the case should be decided? 5, does the witness's testimony agree with the other testimony and other evidence in the case? 6, has the witness been convicted of a felony? Whether the state has met its burden of proof does not depend upon the number of witnesses it has called or upon the number of exhibits it has offered, but instead upon the nature and quality of the evidence presented. The fact that a witness is employed in law enforcement does not mean that his testimony deserves more or less consideration than that of any other witness. Expert witnesses are like other witnesses with one exception. The law permits an expert witness to give his opinion. However, an expert's opinion is reliable only when given on a subject about which you believe him to be an expert. Like other witnesses, you may believe or disbelieve all or any part of an expert's testimony. The defendant in this case has become a witness. You should apply the same rules to consideration of his testimony that you applied to the testimony of the other witnesses. It is entirely proper for a lawyer to talk to a witness about what testimony the witness would give if called to the courtroom. The witness should not be discredited by talking to a lawyer about his or her testimony. You may rely upon your own conclusion about the credibility of any witness. A juror may believe or disbelieve all or any part of the evidence or the testimony of any witness. There are some general rules that apply to your discussion. You must follow these rules in order to return a lawful verdict. 1, you must follow the law as it is set out in these instructions. If you fail to follow the law, your verdict will be a miscarriage of justice. There is no reason for failing to follow the law in this case. All of us are depending upon you to make a wise and legal decision in this matter. This case must be decided only upon the evidence that you have heard from the testimony of witnesses and have seen in the form of exhibits and evidence and these instructions. This case must not be decided for or against anyone because you feel sorry for anyone or are angry at anyone. Remember, the lawyers are not on trial. Your feelings about them should not influence your decision in this case. Your duty is to determine if the defendant has been proven guilty or not in accord with the law. It is my job to determine a proper sentence if the defendant is found guilty. Whatever verdict you render must be unanimous. That is, each juror must agree to the same verdict. Your verdict should not be influenced by feelings of prejudice, bias, or sympathy. Your verdict must be based on the evidence and on the law contained in these instructions. Deciding a verdict is exclusively your job. I cannot participate in that decision in any way. So please disregard anything that I may have said or anything that I may have done to make you think that I prefer one verdict over another. You may find the defendant guilty as charged or guilty of such lesser included crime as the evidence may justify or not guilty. If you return a verdict of guilty, it should be for the highest offense on the verdict form that has been proven beyond a reasonable doubt. If you find that no offense has been proven beyond a reasonable doubt, then, of course, your verdict must be not guilty. The verdict must be unanimous, and that is, all of you must agree to the same verdict. Only one verdict may be returned as to the crime charged. The verdict must be in writing, and for your convenience, the necessary verdict form has been prepared for you, and it reads as follows. And this is the verdict form, and you'll get it along with the copy of these instructions. In the case of the state of Florida versus Joshua Lawson, we, the jury, find as follows as to the defendant, Joshua Lawson, in this case. And then it gives you an instruction in parentheses to check only one option. 1, the defendant is guilty as charged of aggravated manslaughter of an officer. 2, the defendant is guilty of the lesser included offense of manslaughter. 3, the defendant is guilty of the lesser included offense of aggravated battery on a law enforcement officer. 4, the defendant is guilty of the lesser included offense of felony battery. 5, the defendant is guilty of the lesser included offense of battery on a law enforcement officer. 6, the defendant is guilty of the lesser included offense of battery. 7, the defendant is guilty of the lesser included offense of culpable negligence. 8, the defendant is not guilty. So say we all. Dated this blank date of June 2024. There's a place to put the date and for the foreperson to sign the verdict form. In just a few moments, you will be taken to the jury room by one of our court deputies. The first thing that you should do is choose a foreperson who will preside over your deliberations. The foreperson should see to it that your discussions are carried on in an organized way and that everyone has a fair chance to be heard. It is also the foreperson's job to sign and date the verdict form when all of you have agreed on a verdict and to bring the verdict form back to the courtroom when you return. During deliberations, jurors must communicate about the case only with one another and only when all jurors are present in the jury room. If a juror goes to the restroom, the deliberations should stop until that juror returns. You are not to communicate with any person outside of the jury about this case. Until you have reached a verdict, you must not talk about this case in person or through the telephone, writing, or electronic communication, such as email or any other means. Do not contact anyone to assist you during your deliberations. These communication rules apply until I discharge you at the end of the case. If you become aware of any violation of these instructions or any other instruction I have given in this case, you must tell me by giving a note to the court deputies. Many of you have cell phones, tablets, laptops, smartwatches, or other electronic devices here in the courtroom. The rules do not allow you to bring your phones or any of those type of electronic devices into the jury room. Kindly leave those devices on your seats where they will be guarded by the court deputy while you deliberate. If you need to communicate with me, send a note through the court deputy. If you have voted, do not disclose the actual vote in the note. If you have a question, I will talk to the attorneys before I answer, so it may take some time. You may continue your deliberations while you wait for my answer. I will answer any questions if I can, in writing or orally, here in open court. During the trial, items were received into evidence as exhibits. You may examine whatever exhibits you think will help in your deliberations. These exhibits will be sent into the jury room with you when you begin to deliberate. In closing, let me remind you that it is important that you follow the law spelled out in these instructions in deciding your verdict. There are no other laws that apply to this case. Even if you do not like the laws that must be applied, you must use them. For more than 2 centuries, we have lived by the Constitution and the law. No juror has the right to violate the rules that we all share. Is there any objection to the reading of the final instructions? State. Defense.
No, Your Honor.
All right. Mr. Trowell, this is the opportunity where I tell you that you are what we call our alternate juror. I tell you this in the presence of all of the jurors because we are only allowed to have 6 people go into the jury room to deliberate. And I hate this part because I feel like you got all dressed up and we're not taking you out to dinner or to the prom or wherever, right? But your role as an alternate juror is very important because should any of our first 6 jurors had a medical emergency, had an emergency with their family, we could have proceeded with that trial and you would have stepped in their place without ever having known that you were the alternate or whatnot. But the law only allows 6 to deliberate. I say this in everyone else's presence because I want you to know that's why Mr. Trowell will not go back in there with you and won't be deliberating. Okay? So everyone has had an opportunity to get Clerk Brooks's phone number and given it to your family members. Do you need a number that you want? Is there not a phone number on the table in the jury room? There was no number. Did anyone else see a number? Okay, normally there's a number. So Jeannie, help me with that. All right, so this is the number. If anyone needs to reach you while you are deliberating in an emergency, this is the number. So what I want you to do is go into the jury room, take just a few minutes. Do not begin to talk about this case at all. You can bring your notes, okay? Leave, and then make your calls real quick, give whoever you wish the number, and come back out and give us all of your electronic devices and leave those on the chair. Any questions about the logistics? All right, let's everyone remain seated as our jurors leave the courtroom. Mr. Trowell, you're welcome to go grab your stuff. If you'll leave us the juror button, that would be great. And we are all sitting tight in the courtroom, and you are welcome to stay with us, or you're welcome to leave with our most sincere thanks for your time serving.
Thank you.
Okay. Do you want us to call you and let you know what happens?
Yeah.
All right, we'd be happy to. Thank you. The jurors are not present in the courtroom. However, still present in the courtroom is counsel for the state and counsel for the defendant and the defendant. We had some errors in the jury instructions. And so what pages do you have? I have more than one page. Oh, yeah. I need one of your clean instructions. Now I'm all.
Without that extra.
Because, okay, so wait, let me have that. Okay, let's be clear. Where I thought it needed to be changed and what I actually read is in an introduction to homicide. Okay, an introduction to homicide, aggravated manslaughter of an officer. Okay, so let me not confuse this. Do you want to put it back up real quick? I think you changed it, but I don't think you guys printed the last version. So perhaps if you just print the last version.
Your Honor, the stuff I'm looking at, it reads introduction to homicide, Joshua Lawson is accused of aggravated manslaughter of an officer. Aggravated manslaughter included the lesser.
Right, but that's of an officer. It needs to say of an officer, and that's how we changed it.
Okay, I didn't think we changed that, but I thought we changed it everywhere else, but it's okay.
No, I think we changed that, and that's how I read it. And then can we put prosecutor PC on the TVs, please? Pull, without making any changes, pull what you got, because we changed all this. And I just think it didn't get printed right.
Includes lesser crime of manslaughter.
Right. And so there, yes, we need to add the statement that's the words of an officer. And I think of an officer includes, take out a space and then includes. All right. And then keep going down to that last the last paragraph on the next page. There, we changed that of an officer there as well too. I don't think it's saved then, because we made all these changes. Tell them to just give us a minute.
So should it be, if we're doing that, should it be of an officer here as well?
It can, but that's not how I read it. I read aggravated manslaughter there. Yeah. All right. So why don't we take out all those spaces and bring it all up to one page? Nope, it's down, right. Take out those spaces right there at the bottom of that page. All right. And then scroll down, take out that. All right. Okay, there, aggravated manslaughter of an officer is changed. Now keep going. The next place I saw an issue, since we were making a change, I just thought, let's make a change on the weighing of the evidence so that we don't have a big space at the end of weighing the evidence. So go down all the way down. There you go, and just there's a second page, just bring it all up. I think that's it. So if we could just print that. Yeah. Jeannie, you've got the exhibits. Let's wait on the exhibits till we have the jury instructions. Yeah, give it to them, and then if they want to hear it, then we'll bring it back. There's the verdict form, and sit tight on the instructions. It got warm in here. Are you warm or is it just me? Yeah.
It was warm right after we got back, and we're starting to cool down some now. Let me step out real quick while we're waiting on this.
Flag that the net time is now 3. Clerk. Ms. Kelly, do you want to look at these instructions? They do appear to be as I have read them.
As long as they are accurately reflect what was on the screen, I don't need to see them again.
Yep, they do. All right, Madam Clerk. Here are the jury instructions. We've got the verdict form and the exhibits. Let's let the jurors come out and bring their electronic devices. Yes. Everyone remain seated. Ladies and gentlemen, Madam Clerk is about to give you the jury instructions, the verdict form, and the exhibits, and you may now retire to begin your deliberations. So thank you. Chuck, why don't you do it? It's okay, no problem. Let the record reflect that the time is now 3:08 PM. Still present in the courtroom is counsel for the state, counsel for the defendant, and the defendant. The jurors are not present in the courtroom. Counsels, are there any matters that we need to consider outside of the presence of the jury at this time?
No, Your Honor.
All right, then we'll be in recess until we hear back from the jurors. All right. You're back on the record at 5:10 PM. We're still here in the case of the state of Florida versus Joshua Lawson, Jackson County case number 21-610 CF. Present in the courtroom is counsel for the state, counsel for the defendant, and the defendant. The jurors are not present in the courtroom. However, they have advised the bailiffs that they have a verdict. Are there any matters that we need to consider before we bring them in?
No, Your Honor.
Nothing further, Your Honor.
All right, let's bring the jurors in. Everyone remain seated, please, sorry, Gary. Family members, we can only imagine how incredibly difficult this entire situation has been for you. That said, I will not allow anyone to have any visible or audible response, whether it be of joy or of sorrow, when the jury verdict is read. Okay, so if you feel that it may be too difficult for you to sit in this room and have no response, then I would ask you to please leave the courtroom. Otherwise, you will be removed from the courtroom, okay? Because while these jurors are in here, I will not allow any emotion shown by the gallery. Once the jurors have left, you are free to show whatever emotion you wish. But while they're here, we don't do that, okay? All right? All right, let's let the jurors come back in. Everyone remain seated.
Ladies and gentlemen, please take your seat in the court.
Welcome back, ladies and gentlemen. Ladies and gentlemen of the jury, have you reached a verdict? All right, if you can please give the verdict to one of our bailiffs, who will pass it along to me. Madam Clerk, please publish the verdict, and will you do so on a mic? You can turn it your way. That'd be great. Thank you, Madam Clerk.
In the Circuit Court, 14th Judicial Circuit of the State of Florida, in and for Jackson County, State of Florida versus Joshua Lawson, case number 21 CF 610. We, the jury, find as follows as to the defendant, Joshua Lawson, in this case. The defendant is guilty of the lesser included offense of aggravated battery on a law enforcement officer. So say we all, dated this 25th day of June, 2024.
Do either the state or the defense wish for the court to poll the jury?
Yes, Your Honor.
Madam Clerk, please poll our jurors.
Mr. Allen, is this your verdict?
Yes.
Mr. Ellis, is this your verdict?
Yes.
Mr. Everett, is this your verdict?
Yes.
Ms. Lewis Harris, is this your verdict?
Yes.
Mr. Oler, is this your verdict?
Yes.
Ms. Roberts, is this your verdict?
Yes.
Ladies and gentlemen of the jury, I wish to thank you for your time and consideration of this case. And I also wish to advise you of some very special privileges enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in that jury room, except by a court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you a unique privilege not to speak about the jury's work. Although you are at liberty to speak with anyone about your deliberations, you are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or from elsewhere. it will be up to each of you whether to preserve your privacy as a juror. On behalf of the 14th Judicial Circuit, I thank you once again for the time and attention that you have given to this matter. We will make sure that you are escorted back to your vehicles. And additionally, as I have pledged, I will personally destroy any notes that you may have taken in the juror notepads. Please leave those notes along with your buttons and collect your electronic devices, and you can leave all of those on the chair. Everyone may remain seated and the jurors are free to go. Thank you so very much, guys. All right. Let the record reflect that the jurors have exited the courtroom. Ms. Jeffcoat, the defendant was charged with the first-degree felony and if essentially was found guilty of a lesser included offense. However, it's still a first-degree felony punishable by the exact same amount of years as the original offense. Is that correct?
That is correct.
Is that what the defense understands as well? May I see counsel at sidebar, please? Can I have the white noise? No court reporter. Counsel, we've had an off-the-record conversation about the propriety of proceeding with sentencing at this time. The court asked or ordered that inmate Lawson be transported from the Department of Corrections where he is currently being housed. Deputy Hodges with the Jackson County Sheriff's Office actually transported him, and I think he just stepped out to walk the officers out, but he is currently housed in the Florida Department of Corrections. Is that what everyone understands to be the case?
Yes, Your Honor. And Inspector Bassford is present and can also confirm that, but we did orders to have him transported for the purposes of this trial from the Florida Department of Corrections.
All right. Where's Hodges? Can we get, because he's the one who actually got him from, where's Hodges?
I sent him down with Deputy Space to escort the jury.
Could you get him back when they're done? And just for a minute, because guys, what I'd like to do is sentence right now, if we can make that work. So, and I'm happy to consider any arguments that you will make. Would everybody be ready?
Yes, Your Honor. Yes, Your Honor. I can be ready.
All right. Deputy Hodges, if you don't mind coming on up, will you come to one of the microphones, please? Deputy Hodges, if you will raise your right hand, do you solemnly swear or affirm that the testimony you're about to give shall be the truth, the whole truth, and nothing but the truth?
Yes, I do.
All right, Deputy Hodges, last week sometime, you got inmate Joshua Lawson from a DOC facility and you transported him to the Jackson County Jail. Is that correct?
That's correct.
All right, and where did you get him from?
Florida State Prison located in Rayford, Florida.
All right, and that's where you are to return him because he is still serving a sentence there. Is that correct?
That's correct.
All right, and that's pursuant to my court order, correct?
Yes, ma'am.
All right. Any additional questions by the state or the defense?
No, it's fine, Your Honor.
No, Your Honor.
All right, do you want any testimony regarding the sentence that he's currently serving?
Your Honor, I can just, if Inspector Bassford, I think, can confirm that he is still actively serving the sentence.
All right, so let's just get him up here. So Investigator Bassford or Inspector Bassford, if you don't mind coming up.
Details on the top of my head.
Do you know the actual current sentence? No, but
No.
you know that he's currently serving a sentence, and certainly Officer Hodges' testimony
I could get that.
would be sufficient. Why don't you take a minute?
I can get that confirmation. If you give me just a few minutes.
Yeah, that's fine. Why don't you take a minute and then the attorneys can take a minute to look at everything, and then I'm happy to hear any arguments, and that way hopefully we can give some closure to the whole situation, okay? Inspector Bassford, can you come on up? Inspector Bassford, you're still under oath from earlier today. You currently are employed with the Department of Corrections, is that correct?
Yes, ma'am.
All right, and can you tell us whether Joshua Lawson, the individual on trial today in Jackson County, is an inmate with the State Department of Corrections?
Yes, ma'am, he is.
And is he currently still serving a sentence with the State Department of Corrections?
Yes, ma'am, until his current tentative release date is March the 5th of 2027.
All right, fair enough. Can you share with me what he's currently serving a sentence for?
Robbery with a gun or deadly weapon, grand theft motor vehicle, and attempted robbery. So there's looks like 2 counts of robbery, 1 count of attempted, and 1 count of grand theft.
Total 4 felony offenses.
Yes, ma'am.
Is there any objection or does any follow-up questions to the information elicited by the court?
No objection, Your Honor, and the record is stated by Inspector Baxford of the 2 robberies, the attempted robbery and the grand theft are consistent with the certified convictions that we
Of
got.
4. Fair enough. Anything from the defense on that issue?
No, Your Honor.
Thank you, Inspector Bassford. State, whenever you're ready, let me know, and if you need some time, let me know.
Certainly, Your Honor. The defendant has been found guilty of aggravated battery under Florida statute 775.082 subsection 9. It defines.
Most specifically 9A1, right? Okay, I'm with you. Go ahead.
It defines a prison releasee reoffender as a person who commits or attempts to commit one of the enumerated offenses, and under subsection K, it lists aggravated battery. And then it states within 3 years after being released from a state correctional facility by the Department of Corrections, or within 3 years after being released from a state correctional facility operated by the Department of Corrections, a county facility for the sentence pronounced, or following incarceration for an offense for which the sentence is punishable by more than a year. It also means that the defendant under subsection 2, so that would be 9A2, it says, it also means any defendant who commits or attempts to commit any offense that's enumerated, which includes subsection K, while the defendant was serving a prison sentence or while he was on an escape status, would be sentenced pursuant to subsection 3. And in this case, it would be 3B, which is for a felony of the 1st degree by a term of imprisonment of 30 years. In Your Honor, the testimony introduced at trial was that this offense was committed while the inmate was serving a sentence at the Department of Corrections and was an active inmate at the Department of Corrections. And he is still currently serving that sentence, Your Honor.
Response from the defense or any further argument that the defense wishes for the court to consider?
Not as to that, Your Honor.
As to anything?
I was going to say, I believe Mr. Lawson acknowledged from the stand that there was him on the video, and he was serving a prison sentence at that point in time. So the only request from the defense would be that Mr. Lawson should be allowed to serve his sentence concurrently with the sentence that he's already serving, and then he'd be awarded the 2,065 days credit that he has amassed since this incident occurred.
State.
Your Honor, I believe the defendant is entitled to credit since his warrant was served in this matter. The state would ask that this sentence be run consecutive. He still has a few years left on his original sentence. Also, just for record purposes, the state had previously sent a plea offer in the case, which we've gone over on a record before a prior jury selection. And in the email in which I sent the plea offer, it does indicate that I had a discussion with Ms. Kelly that he would qualify as a prison releasee reoffender. And it's my recollection that we also put that on the record with the defendant before picking not the jury for this instant case, but when we attempted to pick a jury and did so last 2 months ago.
When was the warrant served?
And Your Honor, I just was doing math in my head. I believe I misspoke. I just pulled it up from my jail credit from my computer system, and I believe 2,065 days would have been from the date his original sentence commenced, because it's way too long. So
February 10th of 2022. Madam Clerk indicates that he was previously Sir, the warrant for this offense was served on February 10th of 2022.
So as of today, Your Honor, the calculation that I've come up with is 866 days.
For which case, for the chart,
From February 10th.
that's not relevant to this, yeah.
Does the defendant wish to be heard?
You want to address the board? No, you're on.
All right. Does any representative of the victim's family wish to be heard?
Your Honor, Mr. Thomas Weeks would like to speak on behalf of the family. He was the brother-in-law of the decedent.
Sure. Mr. Weeks, if you don't mind, please come on up to one of the microphones, okay? Mr. Weeks, I'm happy to hear and consider anything that you wish to say on behalf of the victim's family.
Yes, ma'am. My sister-in-law, the widow, Matt's widow and his daughter, they don't feel like they could stand up here and speak because it would be too painful for them. Mr. Lawson took away not only a father to Megan, he took away Winona's husband, he took away a brother, he took away my friend, he took away a grandfather of a little girl that'll never get to know her grandfather. The little girl is, she's 8, she's autistic. Matt had a great relationship with her, and now he's gone. He's gone, and she doesn't understand that. And it's been very difficult. It's been a very, very difficult time for everybody. And we're just happy to finally be here and see maybe some justice served. I'm not going to go into opinions and everything about the jury verdict and all that. That's not what I'm here for. I'm here for you, Your Honor, to ask you to just hear that and know that he has taken away basically lives. He's taken away basically lives. For a long time, my sister-in-law wouldn't leave the house. She couldn't do anything. For a long time, my niece, I had to check on her daily. I'm the one, me, that had to go over and wake her up in the middle of the night to tell her father died. And that's something, Your Honor, I never want to do again in my life to anyone. I served in law enforcement for over 30 years, almost 31 years. And I never will forget that. And I pray to God I never have to do it again. What I had to hear and what I had to do for the rest of that night, into the next day, into the following weeks to get everybody through it. Matt was my friend. He was a great friend. He was a great father. He was a great husband. He was a great grandfather. This courtroom could be packed with people today, just as his service was. His service was held in a church, standing room only, Your Honor. It was a huge church, 300 or 400 seats. There were people outside in the parking lot. There were people in the lobby. The lives he's touched, the lives he touched during his life, the people he cared for and cared for him. And that's been taken. It's been taken because of his act, because of Mr. Lawson's act, regardless of the verdict that was given here today or whatever his attorney doing her job has said, and whatever Mr. Lawson says, it was directly related to his act. And he's taken all that away and it's gone. It'll never be back. And I have to deal with that daily with my family. There's some days it seems like there's no hope. And then you just get up the next day and go on. So I'm hoping today we can finally put this behind and just move on is what I'm hoping.
Yes, sir. Thank you.
Thank you.
Anything further from the state?
Not at this time, Your Honor.
Anything further from the defense? No? All right. Mr. Lawson, a jury of your peers has found you guilty of a lesser included offense, aggravated battery of a law enforcement officer, first-degree felony. I have considered the facts of the case. I've heard the testimony here today. I've heard everyone's positions on the sentencing. I will adjudicate you to be guilty of the underlying offense, and I sentence you to serve as a prison releasee reoffender. I find that you do qualify pursuant to Florida statute 775.082, subsection 9A1. The specific offense is subsection K there, subsection 2 under there, because it is proven that you committed this aggravated battery while you were an inmate in the state correctional facility, I find that you do qualify as a prison releasee reoffender, and therefore I sentence you to serve 30 years in the State Department of Corrections. The court is exercising its discretion at this time and is going to sentence you to serve that 30 years consecutive to any current sentences that you are serving. You would be entitled normally to credit, let me say, for the record, you have been in custody for 867 days since the day the warrant was served on this offense. However, because I am running the sentence consecutive, I do not believe that you will be entitled to 867 days of credit for that sentence because you are still serving the sentence that you're currently serving. However, I will state for the record that the amount of time in custody on this warrant has been 867 days. I am required to tell you that if you wish to appeal this court's judgment and sentence, you have 30 days within which to do so. If you cannot afford an attorney, one will be appointed to you for that purpose. Mr. Lawson, we're going to need your fingerprints, and you will be remanded back to the custody of the Florida Department of Corrections to serve out your new sentence and to finish out your existing sentence. Is there anything further from either the state or the defense?
Not at this time, Your Honor.
No, Your Honor.
I would be remiss if I didn't make one address to the family. Yes, sir.
I would like to say one thing. He made a statement saying that
Sir, if you'll put the microphone closer to you so I can
he
hear
made
you.
a statement saying that he had to take care of his niece. I got a niece that's you know what I'm saying, mentally challenged also. All my life I've been going and brought up into the system. I grew up in foster care. All my life I've been going through psychic institution after institution after institution. I grew up in foster care. I aged out of foster care. And the time being, the circumstances in my life been straight crappy. And it was hard for me out there on the streets, trying to find a job and being sabotaged daily, day in and day out. So I'm not saying that to have pity on me. I'm just saying that because of the simple fact that the experience that I've been through and the struggle I've been through, I don't oppose on other people. I don't mess with a lot of people. I'm a recluse because of the simple fact that I have broken issues.
Yes, sir.
Because of the circumstances that I've been through in my life. Other than that, that's all I needed to get off my chest.
And I appreciate you
And
sharing that.
Not only that, I've been torn away from my family. You know what I'm saying? I barely get along with my family because of the simple fact that I grew up in foster care. I barely know them. Even though I done been around them, even though I ran away to be with them. As you can see, they nowhere in the courtroom right now.
Yes, sir.
And I got kids of my own that I have in and out of custody. And I still don't know them.
Mr. Lawson, thank you for sharing that.
Yes, ma'am.
I am taking you into custody at this time.
Yes,
He is no longer, the presumption of innocence as to this charge no longer remains. So I'd ask you to please handcuff him, Sergeant. Who's got the handcuffs?
You want to keep these for your? Okay.
But he's not leaving yet. I'm not done. Family, I'd be remiss if I didn't make the following comment, especially after Mr. Weeks's comments. Even though it's a lesser included offense, I want you to understand that he was found guilty of a first-degree felony, which is the exact same level of offense as the original offense and carried the exact same maximum penalty. And I think that sometimes for the lay people, that is difficult for them to understand. We use terms lesser included offenses, but it is effectively the exact same level of offense. It's just a different offense. Is there anything else that we need to address from the state or the defense?
No,
All right, then we will be in recess. Court costs, fines, and fees will be imposed in the amount of $1,100. That will be reduced to a civil judgment. Is there anything else that you can think of? 1452. Excuse me, it's not for $1,100. It's $1,400.52. Anything else that we need to address?